The only controversy is one relating to monetary consideration. For this limited purpose, we direct the parties to appear before the Supreme Court Mediation Center. We request the center to appoint a senior mediator and try to bring around equitable settlement between the parties, more particularly the monetary consideration. Posted in.
No, not at all, Lordship. Not at all,
It's
Lordship.
like the Indian Divorce Act petition.
It
is
is.
correct?
It is
You
under.
know how
the-
difficult it is there?
My lord, but that is not correct.
No, but
I-
please be, tell your client to be,
And we will, my lord. We will. That is not.
Transfer petitions filed by the wife have already got allowed through order.
What are you doing, ma'am?
She's a doctor. I'm a computer engineer.
Where are you, Muscat?
Muscat. She actually earns more than me, but regardless, Lordship, we will pay alimony.
After getting married, she accompanied you to Muscat.
She did later in the year. She
They lived together for how long?
just about a year before she came
What
back.
went wrong in Muscat?
Your Lordship,
Lordship, she was not happy there.
Happy.
That is my account. That is
Your
my
Lordship-
version. That she had
The
trouble
wife
settling
was
in.
working in Muscat.
She did not have the license to practice as a doctor, but she was working as a claims inspector.
As a
Insurance claims inspector. Insurance claims inspector.
yes, Your Lordship, she worked.
he is an MD.
No, Your
She
Lordship.
is
She,
MBBS.
after finishing her MBBS, she worked for 1 year and after that they got married.
She works with
For
a private
maintaining her
hospital.
marital life, she had to leave her job here and go to Muscat. However, Your Lordship, she faced many
So
domestic-
Muscat created the trouble. It is Muscat which
Your Lordship,
created the trouble.
May I please, Your Lordship?
You have seen many cases.
Lordship, there's one.
Many Indians, they don't find themselves comfortable in Middle East countries or something.
That is true, Lordship.
So perhaps if husband would have been little considerate, anyway, that's your personal. Try it.
It was the
Try it.
misogynistic
Lordship,
attitude. of
Lordship,
the
just one thing, Lordship. On the last occasion, Lordship had ordered that they be present in court. So he's here, if Lordship, virtually. If Lordships would like to speak to the parties, he's very much present.
Next hearing.
Then
But
Lordship,
we make ourselves very clear. Not 5 lakhs, not 2.5 crores. Understood?
Your Lordship,
Your offer, absolutely unreasonable. Your demand, absolutely unreasonable.
Your Lordship, my
Let the mediator talk to the parties,
I will.
convince them, arrive at some reasonable figure, and put an end to it. Next matter.
Lordship, just one other thing. Admittedly, we had paid 26 lakhs towards.
Your Lordship, this is
Let me finish,
this is a
please.
false statement. May I please, Your Lordship?
It's
their
actually an
own
admitted statement.
Listen,
It's an admitted statement. We
Listen.
are willing to forfeit that and then pay some more.
forget about that 26.
We are willing to forfeit that, Lordship.
If
But
you all have paid her, forget about it. Start talking afresh. Next matter.
would Lordship consider appointing Justice Korean Joseph, since they're both from
Good idea.
Kedu?
So you
Yeah.
understand the local,
Your Lordship,
And the context as
one
well.
of the issues that is arising these days in mediation is for the language also. And this will solve it.
I'm very obliged.
Your Lordship,
darling.
they are well versed in English, both the sides, and there is no issue with respect to the language restriction.
But this will help. You have any objection?
Your Lordship, I won't be able to. Your Lordship, I am not well versed with Malayalam as such, so
No, it
can-
won't be in Malayalam. It will be in English.
Yes,
Green Joseph is also well versed in English.
We heard Miss,
Shahrukh Alam.
the learned senior counsel,
Not at all.
learned counsel appearing for the petitioner husband,
Husband.
and Miss,
same letter out.
the learned counsel appearing for the respondent
Wife.
wife. The husband has moved an IA, जरा लाइए तो praying, to pass an order for dissolution of marriage in exercise of our powers under Article 142 of the Constitution. According to the husband, the case is one of an irretrievable breakdown of marriage. However, the IA is unilateral. Full point. At the same time, the wife has also made herself very clear that she doesn't want to continue with the marriage. It appears that the husband is a computer engineer serving in Muscat, Middle East, and wife is a doctor. After getting married, the wife stayed in Muscat with her husband for some time. However, she didn't find herself comfortable in Muscat. Prima facie, it appears that this led to marital discord. Full point. Both have decided to part ways honorably and peacefully. However, the husband is ready and willing to pay rupees 5 lakh towards full and
No.
final settlement.
We are not, that is not something that we had said. We are open to paying much more, Lordship.
However, the husband has made himself clear that he would definitely pay some reasonable amount to his wife towards full and final settlement.
And forfeit the 26 lakhs.
Your Lordship, may kindly not record that.
You talked about this to the media. The expectation of the wife is around rupees 2.4 CR.
2.5, Your Lordship.
Huh?
It's 2.5 CR as per the stated position.
What did I say?
2.4, Your Lordship.
ये मियाँ बीवी के झगड़े में now we are also for
Your Lordship, she was ready
2.5
without
CR.
taking anything.
2.5.
But then they kept on harassing her.
Okay, don't harass us, ma'am. 2.5 CR. In such circumstances referred to above, we appoint Honorable Justice Suryan Joseph to a former judge of this court, former judge of the Supreme Court, to act as a mediator and bring around some equitable settlement between the parties. The fees of the learned mediator and other modalities shall be worked out in consultation with the mediator. Once we receive the report of the learned mediator, we shall proceed further with the matter.
Deeply obliged.
Part heard, my lord. Part heard.
Part heard, part heard.
I'm very obliged.
Deeply obliged.
Very obliged.
Yes. Yes.
This is the transfer petition, criminal, from Delhi to Tirunelveli, checkpoints case, my lords.
Check bounce.
Whether section is the judgment.
Have you gone through the recent
Yes,
judgment?
yes, that home branch is Bangalore. They
So, where was this check? How many checks are there?
only one check, my lords.
Where was it presented?
In Delhi, my lords.
The collecting branch? Where is the collecting
is
branch?
Bangalore, my lords.
Bangalore.
Yes, my lords.
And the complaint has been filed in Bangalore.
Not here, my lords.
Then what is the problem? Pay's branch.
Pay branch in Bangalore, my lords. Main branch.
Then how come the check came here in Delhi?
Here is presented check in Delhi. The here is Dwarka, my lords. This only taxi driver, my lords.
Taxi driver.
Commercial vehicle, my lords. 6 lakhs amount we paid the 2 lakhs 90,000. Only 3 lakhs.
Stage of the trial.
Trial is still summoning to the accused, my lords.
Summons have not been issued.
Someone issued, the
How did you
NBW
come-
issued that
How did you come to know that the complaint has been filed? If
we,
summons,
someone we received, NBW issued my lords against me, then we filed.
NBW,
Yes, ma'am.
you must not be appearing over there.
Yes, my lords.
You notice. What is the amount?
Amount is 6 lakhs something. We paid 2 lakhs 90,000. Remaining amount 3 lakhs
You
90.
purchased a taxi from this amount.
Yes, my lords. Commercial vehicle.
After notice.
After notice, my lords. Yes.
Nobody is appearing. Transfer it. Chalo.
Bless me.
The respondent, although served with the notice issued by this court, yet has chosen not to remain present before this court and oppose this transfer petition. Then transfer.
Your Lordship, in this settlement agreement was agreed on 24th of November 2025. As per that, Your Lordship, we'll be filing a joint 142 application
Okay.
by the third week of December, Your Lordship.
When will you file it?
In the third week of December, Your Lordship, commencing.
We are informed that the parties have been able to settle the matter
Yes.
before the Supreme Court Mediation
Yes, sir.
Center. The settlement agreement has also been reduced into writing. A joint petition, according to the Learned Counsel, the parties would be filing a joint petition
Yes, Your Lordship.
seeking dissolution of marriage. Okay, post it in the third week of December.
Obliged, Your Lordship.
Please, my lord. Not be seeking the transfer from Gadak Court to the Madras High Court.
Huh.
My lord had appointed an amicus.
Yes. This is relating to that.
Wheel and active.
Yes.
May it please your lordship.
Ah.
Lordships have prepared a note and a compilation for your lordship's kind consideration, if I may tender. So from the documents, if your lordships could have page 1 of the note, what I propose to do is take your lordships through the chronology of events very quickly, show what is emerging from the pleadings before the two courts, and then the principles under section 25 and section 10 CPC. Lordship may kindly see page 1. The petitioner herein, HUL, claims to have been using the registered trademark wheel from 1960. It's a valid registration. And thereafter, there's a registration of a mark active wheel in 2008. In April 2015, a suit is instituted before the Honorable Madras High Court, wherein the petitioner herein claims that the respondent number 1, is using the mark, in your lordships may note, double whale. So it's not double wheel at this point of time. What is asserted is respondent number 1 is using a mark double whale and therefore is passing off substandard washing powders and detergents as that of the petitioner. So therefore, a perpetual injunction as well as rendition of accounts are sought. And your lordships may just note the claims in the plaint before the Madras High Court are both infringement of registered trademarks as well as passing off.
Phonetically similar, Mr. Ani.
Phonetically similar, but there is something turns on that, your lordship. And your lordships will see.
Original suit 12 of 24 is instituted by
By respondent number 1
against HUL.
against HUL at Gadak, Karnataka in 2024.
Saying what? Praying for what?
Lordship, the respondent number 1 has set up a defense that he has acquired a registered copyright and a trademark by the name and
Double
style
whale.
of double wheel. Now he says double wheel. So after the suit is instituted, and that's why I wanted to take your lordship through the chronology, because the parties, in a way, your lordship, I don't have a better word, improve what they stand from what they originally filed. If your lordship could kindly see page 2 of the note.
So he amended the plaint.
He did not.
So from where do you get this whale?
Lordship, that is in the written statement filed by respondent number 1 before the Madras High Court. Double whale is in the written statement, if your lordships were to have page 2 of the note.
Who is respondent number one?
One Mr. Satish Honali, who owns a proprietorship concern based in Gadak, Karnataka.
Goes on to improve, my lord. So I get an injunction from the Madras High Court for double whale. Despite the injunction, he now starts selling double wheel.
So respondent number one is supporting the plaintiff.
No, I'm so sorry. Let me clarify, Your Lordship. The plaintiff HUL files a suit before the Honorable Madras High Court claiming infringement of his registered mark and passing off. Respondent number one is the defendant in the Madras High Court. Sets up a defense that his trademark is double whale. The Honorable Madras High Court passes an ad interim injunction. Respondent number one enters appearance, files a written statement, and asserts the use of his trademark double whale. Thereafter, the plaintiff discovers that after the institution of the suit and the granting of the interim order, respondent number one has now started marketing his products as double wheel.
Okay.
And he files another set of applications before the Honorable Madras High Court. The Honorable Madras High Court, after hearing both parties, finds that the use of the mark double wheel by respondent number one is again similar to the products being marketed by the plaintiff / petitioner before Your Lordship,
Correct.
and passes injunctions thereupon. Thereafter, evidence is led. In the evidence, respondent number one asserts double wheel as well as double whale before the Madras High Court. And evidence is closed. The Madras High Court posts the matter for final arguments in March of this year. In the meantime, respondent number one does the following. He registers a trademark and a copyright under the name Double Wheel between 2017 and 2021. And in 2024, institutes a suit in Gadak, Karnataka,
Correct.
now asserting a right under the mark Double Wheel, Double Safedi. I must also inform Your Lordships, Double Wheel, Double Safedi.
But they don't have a registered mark of double at all.
They don't have.
active.
They have wheel and active
active
wheel.
wheel.
Active wheel, and only your allegation is that the artistic work is identical.
Yes, my lord, despite the injunction granted in my favor by the Madras High Court, even for double wheel, he not just goes on to use it, he files a suit claiming the similar mark.
But
Lord-
have you taken any steps on his registration?
My lord, the parties are taking, we have instructions that they are taking steps. But my lord, if my lord sees Annexure P6, which is the order passed by the Madras High Court on 23rd December 2020, Lord, I have a protection and he's been injuncted from using my active wheel qua passing off. The High Court observes that as far as trademark and copyright is concerned, parties are given liberty to decide that issue. But because an injunction operates, not despite the
Your suit is at what stage?
not final arguments in Madras High Court.
And this suit in
It's
Karnataka-
at the summoning. Just the summons have been received. We have filed a written statement.
Now, before the suit proceeds in Karnataka,
Lordship,
if you are able to obtain a decree in your suit,
please, my lord.
what will be the legal implications again so far as this suit in
Won't be made.
Karnataka is concerned?
It won't be maintained.
May I venture an
May
answer?
have a res judicata effect.
Yes.
It will have a
Canara Bank Avasti will have to be applied. Pending appeal, what is the position?
My lord had asked a query for section 10. So we looked up for a judgment by this honorable court.
And by the way,
Please, my lord.
just think over,
Lordship,
if we transfer the suit,
please, my lord.
it will have to be consolidated. Once it is consolidated, evidence has to be recorded in one particular suit. Parties are the same, issues are the same. Are you not going to thereby delay the outcome of your suit, which is now at the stage of final arguments?
Absolutely correct. What you
Lord.
take hint from what brother is saying.
Of course, consolidation doesn't mean if there are issues other than, different, those can be considered.
Lordship.
But you are taking a big chance. If we transfer it, the learned amicus has taken pains to, in his note,
Please,
he has referred to many judgments also.
please, my lord.
Indian Overseas Bank, Chiti Valasa Jute Mills,
Yes, my lord.
Durgesh Sharma, Atomberg Technologies. But you think over and come back.
Lordship, may
You can talk to your clients.
yes. My lord, may pass it over. I'll seek instructions.
Today itself.
My lord, may give me a week's time. I'll seek formal instructions. I'm grateful.
May I only,
Huh.
one last submission for your lordship's kind. A query had fallen from your lordships on the last occasion on the relationship between section 10 CPC and section 25 CPC.
Yes.
There's one judgment of your lordships
Yes, we are.
rendered in 2004, which is Gupte Cardiac, which your lordships will find at page 50 of this compilation. Gupte Cardiac had considered a transfer petition favorably. The principle which your lordships will see at page 51, only to apprise your lordships, because your lordships have put a query to my learned friend and absolutely appropriately. Your lordships were to see para 4 and 5 at page 51. It has not been disputed at the bar that the two suits arise out of the same transaction. Cause of action of one party arrayed as a plaintiff would be his defense in the suit where it is arrayed as a defendant. Though there are two plaintiffs and two defendants. Your lordship may skip that, then your lordship will see para 5. The suit at Nasik has been instituted first in point of time. By reference to section 10 CPC, the trial of the suit at Delhi, being the latter suit, shall be liable to be stayed. For the exercise of his discretionary jurisdiction under section 25 of CPC, the only consideration which is relevant is expediency for the ends of justice. The court will have regard to and respect for the rule enacted in section 10. Of course, the considerations such as which is the place where most of the evidence is available, convenience of the parties and witnesses, which one of the two places is more convenient to access and attend, and so on, are also the factors to be kept in view. May in an appropriate case persuade the court to direct a transfer of case in departure from the rule underlying section 10 of the code.
So this is one more option available with him. File section 10 application in Karnataka.
It's my respectful submission that is a remedy to be elected by a particular plaintiff, whether he seeks a transfer or he opts for a remedy under section 10.
In this case, in Gupte Cardiac, ultimately it was transferred.
Yes, sir.
But what stage was the first suit in Gupta Cardiac? What my learned brother put was, they are far advanced into the first suit.
Lordship pleases. Lordship in Gupte, if your lordship were to have page 50,
If they opt for this transfer,
It will-
as you said, elect.
it may have impacts.
It will have impact on
It
them.
will have an impact. Your lordships are absolutely correct.
But what is the thing which forecloses them after the transfer from excising section 10, saying if section 10 principle is to avoid conflicting decrees,
Lordship.
it may still emerge
I bow
that
down.
conflicting decree
Absolutely.
may arise in Madras.
Your lordship's consolidation is something which your lordships have adopted as a recourse when allowing transfer in Chitti Vasla. Because your lordship said that consolidation, although not contemplated stricto sensu under the code, can be resorted to under section 151. And your lordships normally do consolidate. But a number of the judgments which we came across in our research, all of the suits where transfers were sought were proximate in time and stages.
Let him take instruction there, whether it is absolutely right.
I'm grateful.
Just a minute. Mr. Anand Verma, the learned amicus, has taken pains to prepare a very exhaustive note, giving us more than a fair idea as regards the facts of the two suits, the position of law, more particularly the interplay between section 10 of the CPC and section 25 of the CPC. Good point. After hearing the learned counsel appearing for the petitioner and the learned amicus, we brought to the notice of the learned counsel appearing for the petitioner that if we transfer the suit from Karnataka to Madras, then the two suits will have to be consolidated. Common evidence would have to be led. We had to bring this fact to the notice of the learned counsel because the suit instituted by the petitioner, namely HUL, is at the final stage of arguments. Perhaps the consolidation may delay the final adjudication of the suit instituted by the petitioner. Full point. In such circumstances, we want the learned counsel to seek appropriate instructions from his client and come back to us. We also brought to his notice that his client can move an application under Section 10 of the CPC before the Karnataka High Court.
Right.
Full point. Post it on Friday week, not this Friday, Friday week.
Very grateful to your lordship for permitting me the opportunity.
On the contrary, we appreciate the efforts put in by Mr. Anand Verma, the learned amicus. Full point. Thank you.
Very grateful.
Great.
My lord, the transfer petition, respondent husband has filed a divorce petition in Lucknow. My lord, this honorable court had sent it for the mediation.
My learned friend is appearing through VC, Your Lordship, who has participated in the mediation proceeding which was referred by Your Lordship.
Mediation has failed.
Yes, Your Lordship. The mediation,
Marital life of how many years?
3 years, Your Lordship.
No child, na?
No child.
One child is there, my lord. 23
child was born.
23 months old girl child is there, my lord. And the husband is not maintaining, he is not supporting.
Ek second. Husband, what is the husband doing?
Lord, the husband is an engineer in IOCL.
IOCL.
Indian
My
Oil
lord.
Corporation, my lord.
My lord, currently posted in Chennai.
Are you paying something to your wife towards maintenance?
My lord, as of now, I am not paying anything, but
And
she's
are you paying
working.
something to your child?
My lord, medical expenses, etc., have been paid. Apart
Acha.
from that, no regular maintenance amount is being
No,
being
my
paid.
lord.
We ask him to deposit.
Even the wife is struggling for getting her.
Why mediation failed? What was your demand?
My lord, on first date, the respondent appeared and took the next date. That
Fine.
I will. And
What was the-
70 lakhs.
70 lakhs. And what was your offer,
My lord,
Mr. Mishra?
I am a 29-year-old engineer. My lords, I don't have that kind of a money. My lords, 70 lakhs is too much for me. I'm only 29 years
70
old.
lakhs.
70 lakhs, 70, my lords.
Acha. So ultimately, what was the amount that you offered?
My lords, I offered 20 lakhs.
20 lakhs. You have a small child. The child will grow up.
I'm willing to pay for the
education.
child
Huh?
separately, my lords.
Pardon?
I'm willing to pay for the child's maintenance, my lords.
So you do one thing, 20 lakhs for the wife and perhaps equal amount for your child, and we dissolve the marriage. Put it to your client. Put it
My
to
lords,
your
I'll seek
client.
instructions, my lords.
Huh?
I'll seek instructions from the
Take
client.
My lord, instead he is threatens on phone that your father has her father is expired. You will also be sent there. Either you withdraw the in this transfer petition or
Okay, chalo.
at least my lord,
Marital life of the parties?
My lords, marriage around
3 years.
5 years. Around 4.5 years.
What is your client doing?
no, she is unemployed. She's
lord,
she's not doing anything, my lord.
My lords, she is BTech computer science, my lords.
Just
She
a
was
minute.
employed.
And
Gainfully
recently he has
employed.
purchased 70 lakh property, despite he is having other properties, my lord.
आप हमें लिखने तो दीजिए. आप मियाँ बीवी के झगड़े में हमें क्यों परेशान करते?
Lord, at least
Take down. The parties are married past 3 years. In the wedlock, a girl child was born. The minor daughter is being brought up by her mother. That is the petitioner before us. The husband is serving with IOCL. He is 29 years of age and is an engineer. We are informed that the mediation failed. The wife expects rupees 70 lakh towards full and final settlement. Whereas on the other hand, the husband is ready and willing to pay rupees 20 lakh towards full and final settlement. For the present, we proceed on the footing that reconciliation is not possible. We are of the view that rupees 20 lakh is a meager amount, keeping in mind that there is a child born in the wedlock. In such circumstances, we want the learned counsel appearing for the husband to take instructions, appropriate instructions. We want the husband to pay an amount of rupees 20 lakh to his wife and an equal amount for his daughter. First off. In the meantime, we direct the husband to deposit an amount of rupees 5 lakh in the account of his wife by RTGS within a period of 8 days from today. Posted on Friday week. Next matter.
Grateful.
May please, my
Your
lord.
lordships. This matter was referred for mediation, but the parties couldn't arrive at a settlement.
Settlement.
No,
No, my lord,
parties
could
couldn't
not
arrive.
arrive. Settlement failed, my lords. Mediation
Marital life of
Lordship, 1 year and 4 months.
no child. Na?
No child.
no child.
What is your demand?
Lordship, my demand was rupees 20 lakhs.
Huh?
Of those 20
That's-
lakhs,
that's
5.5
too
lakhs
high.
was
20 lakhs and
of those 20 lakhs, 5.5 lakhs is a sum owed by the husband.
your demand
Yes,
is of
lordship,
20
total of
lakhs.
20.
What are you doing?
My lords, he is a tailor, my lords.
Who is a tailor?
The husband.
Huh?
He works as a laborer in different places. He used to work in Delhi, but after this incident, he has moved to Hardoi, my lords. He is in his native place. My lords, currently he is,
What is your offer?
my lords, the difficulty is that he doesn't have any money, but the demand was so high that he could not even make an offer, and it was very rigid from their side. My lords, there was a
Lordship,
My lords,
in the
there was
Arab of
another
After
date given.
referred, the husband wants the wife to move to his place and stay with.
My
You
lords,
don't want to go.
No, Lordship. She is scared of her safety
my lords,
and
parties came
what has
physically
gone, what has the past, how he has treated me.
My lords, the demand was too high. In fact, we also.
Parties to personally remain present before us on so and so date.
Lordship, can
Ask them
virtually.
to. No.
There will be some difficulty for them to travel.
Why?
The petitioner is dependent on her father. He's a mason.
Husband shall deposit an amount of rupees 5,000 with the registry of this court towards traveling expenses of his wife. Full point. Next matter.
Grateful.
Grateful.
Lords, the petitioner was, Lords, director of a company, Lords. Prior to Lords, registration of the FIR, Lords, she had resigned in 2021. The FIR registered in 2024 for an incident of 2023. Implicated in the case, Lords, only because she's the wife of the main accused.
Shruti Kumari.
No, she's the complainant. I'm for Rasmita, Lords.
Rashmita.
Please, Lords.
And what?
Mediation and all. High Court has only referred to mediation.
Lords, it has referred to mediation, but Lords, with the condition that if it is not resolved, while disposing of the petition,
Section extends till January.
Lords, it extends till January, but Lords, the situation that I've
Today is the last day for the protection in High Court.
Lords, it goes till January, Lords. Last it was listed on 29th of November. Now it's listed for 20th of December.
So
Lords.
4 months, High Court expires when?
Lords, Lords, the High Court order is 17th of 9, 2025. So 4 months from that, Lords.
January. Extend the protection till then, mediation with that.
What happened? Your client?
Lords, no allegation against me, my lords. The FIR says that the one of the companies, my lords, they proposed to, my lords, supply some electric scooters, and that agreement could not be fulfilled because of certain difficulties.
You High Court, you made an offer.
Yes, my lords, that was.
You read the recent.
I have, my lords, I have known. But that was there, my lords, because we were hopeful that there should be some.
So when you offered, the court said go mediate.
Yes, my lords. But my lords, the atmosphere that is being created in the mediation center, because my lords, the complainant party is a local, my lords, they're asking for 5 to 6 times the amount. The amount is, as per them, there is only a breach of contract, and the amount is only 19 lakh rupees, my lords. But when I go for the mediation, keeping in view of the fact the order passed by the High Court that if the settlement does fails, my lords, the application would also go. The protection would go. So, my lords, I am under pressure there, my lords. So, my lords, I may be heard on merits, my lords, and my lords, I'll address my arguments on that aspect.
You continue the mediation.
I'll do that, my lords.
We extend the protection till the matter is taken up next year.
Please, my lords.
That's all you want.
Please, my lords. Please, my lords. That'll serve the purpose.
You are?
I'm representing the state, my lord.
Why is state coming without notice?
After the circular, my lord, in the bail matters, my lord.
Circular then.
So, which is the next date before the mediator?
20th of December, my lords.
So we'll keep it in January. The petitioner before us is a lady. She prayed for anticipatory bail before the High Court in connection with Chhapra Mufassil Police Station case number 345 of 2024, registered for the offence punishable under sections 406, 420, 467, 468, 471, read with 34 of the Indian Penal Code, for short the IPC. While disposing of the anticipatory bail application, the High Court thought fit to direct the parties, that is, the petitioner herein and the complainant, to appear before the District Mediation Center for the purpose of resolving the dispute amicably. The High Court clarified that if the petitioner would fail to appear on 17/10/2025 before the Learned District Court or any date that may be fixed by the learned mediator, the interim protection granted to the petitioner would automatically stand vacated. The petitioner has appeared before the mediator. The talks for settlement are in progress. We are informed that the next date of hearing before the learned mediator is 20th of December 2025. Full point. In such circumstances, post this matter, कोई एक डेट दीजिए जनवरी में. Okay?
Please, my lords.
The interim protection earlier granted by the High Court to continue till जो भी आप डेट देंगे ना वो डेट. Okay? Yeah. Issue notice. Mr. has appeared, as learned counsel has appeared on behalf of the state. Okay?
Deep level. I'm so good.
Lordship, and the council is not well, so kindly grant the adjournment.
Counsel is not well.
Yes, sir.
Your matter is also not well, ma'am. I'm very sick, more than your counsel sickness. 26. Gone through the matter, huh? Chalo, assist us. What is this matter about?
This is related to the property dispute that is.
What type of order are you challenging? You have the file with you? Huh? So, you prayed for a writ of certiorari. What type of order was challenged before the High Court?
Your Lordship, kindly grant the adjournment.
You challenged order of 25th April 2009. Oh, your writ is also of 2009. And there's a delay of 2650 days in coming to this court. The Learned Counsel, we are informed that the Learned Counsel who was to appear in this matter is sick. Post it after 2 weeks.
Thank
Minutes.
Ah.
Minutes, very quickly, brief facts of the matter, minutes. The entire dispute in the matter, minutes, arises on 24/5/2025, when the president and the secretary of RSFI, minutes, they issue two separate minutes of meeting, minutes. The president.
They're all in Vizag.
Milord, in
Milord,
fact, just one second.
I'll just
The interstate dispute between me and Mr. Nair, Milord, should not affect the games.
It is.
But what we are only suggesting is this.
What happened
No,
to
one
the
second.
Union of India status?
Yes, Milord, kindly see the status report said that a meeting has to be convened. And in that meeting, Milord, it will be decided. The High Court now decides, forget the meeting, let the games go on because it is in Andhra Pradesh.
What happened? Tomorrow is the game.
Tomorrow is the game. 4,000 skaters are expected. 2,600 are
That
in
is but
Vizag.
correct,
No, I have taken
As
instructions.
per the website
1 minute.
report.
I'm just informing my lords.
That is all
2,000,
information.
one second. 2,600 skaters are in town. 85 lakhs has been spent by the Vizag municipality. The games are, they are waiting for 1 year for this event. Interstate dispute, lordship may see whenever it's where, but the event should go on. 10 days, 4,000 students are all over India.
Well, it's
Out of 24 associations, 20 are there.
Milord, forget about, Milord, what my learned friend is saying. Please see what the Union of India is saying, Milord. The Union of India is saying none of the state associations want to come. Please have a look at that.
Sort it out. National games.
Yes,
you should not interfere.
Correct, Milord.
Minutes.
Mr. Mehta?
May I submit minutes?
Mr. Mehta.
The presence of, oh, he is here.
Minutes, may I?
This is the skating national games. There's a writ petitions going on. He is a third party who has come with a leave. Union status report was called for. You filed a status report, but on that there is no adjudication. Now an interim stay and a commissioner appointed to see the feasibility of the stadium, etc. Right? He says tomorrow the games are fixed. 4,000 skaters have come.
Almost expected.
Yes. 2 o'clock. You please tell us. We'll go by what.
Yes.
Immediately consult the minister.
Lord, the Union of India should give a status report. According to us, Milord, the stadium is not even ready. None of the state associations are participating. My learned friend, Milord, on instructions, I'm saying making a false statement.
No. My instruction is 2,600 have come.
The Union of India can verify that, Milord. We are open for verification.
Not 4,000.
If I may,
Order
two brief submissions.
the last date, my lord, the order passed by High Court yesterday records that inspection has been done, stadium is ready. There is a joint inspection report as well. I will forward it to my lords for
So that is all but petitioner minutes.
Go to
Minutes, may I make a brief submission? Minutes?
Can you do it at 2? Let us have the factual thing.
That's true.
My lords, in fact, two separate documents. One is the order of the High Court, which has been passed yesterday. Another.
Mr. Kamath?
Yes, Milord.
Who are you?
Milord, I am the respondent number 4, Milord. I am the president of the Milord Federation. My learned friend appears for the Milord.
Tulsi Ram Agarwal?
Yes, Milord. My learned friend appears for the secretary.
What is the name of your federation?
Lord, this
Rolling Skate Federation of India.
Okay. Who are you, Mr.
Milord, I am for the General Secretary, and I was originally the person who was objecting to the misfeasance by the
General
President.
Secretary
of the very same organization, of the nodal body.
Who happens to be from Andhra Pradesh. He wants to.
There's no crime in being from Andhra Pradesh. Why is
Who are
that?
you?
I am its Uttar Pradesh Roller Skating Association. I have more than 1,800 registered.
What is his
skaters,
locus,
Milord.
Milord?
And the High Court, Milord, at the instance of one state association, Milord, only Andhra Pradesh State Association and then Telangana State Association has moved.
You
for the
don't
High
want the event to happen.
Milord, that is not our primary
What
submission.
relief are you seeking today?
Milord, I am seeking, Milord, that 2,000 players of Uttar Pradesh, Milord, were not able to participate.
Why?
Because of the contradictory bulletins. One bulletin says that the events will be in Tamil Nadu, in Bangalore. The other bulletin says that it is going to be in Visakhapatnam, Milord. And then, Milord, High Court itself, Milord, till 28/11/2025 doesn't decide on the venue. It waits first for the report. By order dated 1811, it waits for the report.
In skating, you lose control. 2 o'clock, you finish.
Milord, he is the parent.
The
He is
now
parent.
India come back, my lord, we'll go by whatever the government is saying. The government is
effectively
saying
on
that the
third,
stadiums are ready, my lord. Then that's the end of the matter. If the government is saying stadiums are not ready, Mr. Nair cannot now, my lord, decide whether the stadiums are ready or not. In fact,
There's an order. There's an order.
Tomorrow.
my lord, the
That's right.
painting, my lord, I've got the videos. The stadium is not even ready.
Mr. Kam.
Yes, my lord.
One second.
My learned friend has given me a copy of the order passed by the High Court of Andhra Pradesh at Amravati. I'll just read the relevant part. Peruse the report submitted by the learned advocate commissioners as well as the joint report submitted by District Collector of Visakhapatnam in concurrence with the District Sports Development Officer, District Sports Authority of Visakhapatnam and District Sport Authority Kadapa. From a perusal of the aforesaid report, this court is of the prima facie opinion that petitioner has made all necessary arrangements for smooth conduct of 63rd National Roller Skating Championship in Visakhapatnam as per its schedule. Thereafter, the collector is joined, etc. My lord. This appears to be the position as per the report.
Let the, my lord, Ministry of Sport, my
Minutes,
lord,
with regard to that, just one brief submission, minutes. Now, the order itself would reflect, minutes, that the venue is finally decided on 3rd of December, minutes.
Just a minute. You are aggrieved by an interim order, right? You are aggrieved by an interim order. Till then, there shall be interim stay as prayed for in IA number 2 of 2025, and the fourth respondent shall maintain status quo.
Minutes, I am not aggrieved by that, minutes.
Then why have you come here?
Because, minutes, as I submitted, minutes, subsequent to that, before the parties were, before the High Court's minutes, contradictory bulletin, one from the President.
You want us to look into this order, na?
That's right.
You are in the
Second.
No, yes, minutes, in 08951, 68951.
3rd of September 2025 order, na?
Minutes, 18th of November, that order, minutes, and then.
Where is that 18th November order?
Minutes, that is impugned, minutes.
68951.
Sorry, minutes, 14th of November, minutes, impugned order 1 minutes.
You are in 11.1?
He's in both.
2 minutes, 6895, diary number 68951.
11.1. 11 and 11.1.
Minutes. In 68951 minutes.
That's the order appointing commissioner.
That's
Yes, minutes. That is the last order.
And what about item number 11?
that's from Andhra.
That's
That
why
and Telangana and the
Telangana.
one
Minutes.
is
Telangana has also passed a similar interim order staying the conduct of SGM minutes.
So your case is that many participants from different states
already reached.
have not been able to.
Most of them minutes.
Fine. Okay. Mr. Kamath says the infrastructure is not
Apart
ready.
from that, my lord, my learned friend is right. Kindly have the Union of India's report, my lord. Just
exact.
have one page, my lord. Just have one page. Therefore, the Union of India can come back.
Mr. Nair says
Yes.
2,500 status have come.
The Union of India can come back at 2
Stadiums
o'clock.
now,
Their own website minutes.
now let
says
Mr.
only
Mehta
1,000
come at 2
2
o'clock.
o'clock, no difficulty. Yes.
Whether the infrastructure is there,
All the associations are
whether
participating.
participants have reached,
No difficulty.
and if there are any other impediments
Yes, my lord.
in the proceeding further with the event tomorrow,
Correct.
as
So
scheduled.
ultimately, my lord, India is hosting the, my lord, wanting to host the Olympics. These national games have to have some sanctity, my lord. It has to be done in
These
a
are
proper
not
manner.
national
All our
games, minutes.
participants should come, but in a proper atmosphere. That is our respectful. That the Union of India should, my lord, step
Should
in.
you not be on this side?
My lord,
That's what I told
I am arrayed as
you.
a respondent, my lord.
Doesn't matter, but
I'll
if
be
you
on
are
that. Yes.
supporting him.
Milords 20. Milords out of 24 associations were in nationwide, 20 are there. My learned friend has recently been ousted from his post.
Sure.
His association is in Vizag.
Government
Minutes,
decided.
the-
In fact, there is no
This
confusion
is from their
because High
website.
Court,
Minutes. Only 1,100
Milords,
players
High
are there
Court
out
had
of
already
35,000.
stayed communication by the president on 14th November itself. So there was no confusion with regard to that.
It's the one-day event.
No,
My lord,
it stretches from 5th to 15th. 10 days.
Starting from tomorrow.
5th to
15th of
12th.
December.
every day the
Some of the
participants
other event will be
Different categories of events.
within the stadium.
that complex.
There
It's a
are many
smart city
stadiums,
complex.
multiple stadiums.
Called Smart city
Skating,
complex.
skating.
We'll come back at 2 o'clock.
Fine, come back.
Grateful.
Overnight parted.
2 o'clock
There
today.
is one matter of that circular regarding fraud. Can it be at 2? Lord, I'm in an overnight parted. My turn is coming.
Once we are done with this overnight parted, then we'll look into.
Yes, but it may not be before 2. That's the request. My turn is coming.
It's already 11:45. This
Let-
will go on for about an hour.
Very well, please.
8.
This was item 8.
8 is the one.
That's what was mentioned by the learned SG was item 8.
हाँ, 2 बजे के बाद.
Abhishek, there is.
Yes, Mr. Shankar.
Yes, Manoj. Lord, yesterday evening, we were at a point where I was trying to persuade my lords that the data is contaminated, which the AO picked up for buttonholing me. And a deeper dive really, because your lordships left me, because please see, show me my volume 1, please. Volume 1. So there were 2 data sets, my lord. I'm just broadly saying, my lord, your lordships need not at the moment see the papers. Sorry, your lordships are saying something. 2 data sets.
Just opening it.
Oh, sorry.
The
No,
file has to be opened.
I'm so sorry, my lord. I enter.
Open.
Okay. Okay. My lord, there are 2 data sets before my lords. One is the table that your lordship saw in the AOs. That's the adjudicating officer's order, my lord, based on which certain questions were put to me. The other is, my lord, which again SEBI had, which SEBI was not providing to me despite requests, because I was asking them, what is the source of your data? You're saying sell order 100, you bought only 10. I'm just giving a broad example. So what is the source of your data? My lord, in one of the inspections, I discovered what NSE, because NSE is my pain point at the moment, gave them some data. The figures given there of sell orders and the figures that they have noted in the adjudicating authorities' orders don't match. 1. And there are several entries. I have made a compilation of that. 2, the buy orders are also deflated. So suppose I had made a buy order on a particular date of 10 lakhs. In the adjudicating authorities' order, it is shown as 8 lakhs. I showed those 2 entries. 1 crore plus, they showed 30 lakhs. Lord, please see the difference. And I'm so sorry. I raised those grounds in my reply to their show cause notice. The adjudicating authority notes my reply to the show cause notice, doesn't deal with it. My lord, I had raised those grounds even before SAT.
Let us look into
Yes. Can I just give a table, because I don't want my lords to. That is. Can I just give this? This is from the record.
Because, just to make a mention, my friend can just, I'm not interrupting but the data is what they have placed on record is not part of the email which he has annexed. I'm not wasting Lordship court time, because unless the court gets into this controversy and the inquiry, factually, document at page 148 is not the document attached to 147, factually. So my friend, of course, may bear in mind.
Lord, I don't know.
There is.
Now, this is completely.
I'll not talking, my lords. I am before Supreme Court. My lords, I've taken specific instructions on this. I can show my lords, even from the bare perusal of 147, my friend read to your lordship court yesterday, is an email communication by NACL to SEBI. 148 is a chart. The document 147 talks about DVD, enclosed DVD, not the chart. And this chart is a reflection of data from NSC and BSc. NSC will not give document or information of BSc. And I've got email communication from SEBI saying this chart is not part of DVD sent to us by NSC. Before SAT, we have filed a counter placing on record the email received from NSC, with which we have attached the entire trading transactions of every day, not disputed. Just 1 second, sir. Before the SAT, this argument is not raised, not discussed. Therefore, I just stop it here. Lordship, just whenever I have the chance, I can show your Lordship court this is factually incorrect.
Let him show.
Yes, my lord. What my learned friend won't answer is, I showed 2 grounds in the SAT appeal, my lord. GNH, in which I raised in specific instance of 2 entries which I showed to my lords of sell orders and an H of buy orders. What is their reply to those grounds, my lord? It's a perfunctory reply. Denied.
We'll go with that. We'll keep the denial on one side. What he's saying is, you have sent a mail saying your data is a mismatch because NSE has furnished certain data, and that is the annexure. The annexure given by you, he says, is not what is furnished by NSE to them, because NSE has given it in the form of a DVD or a electronic form.
There is a log. That's why I said, Milord, I asked the adjudicating authority, please give me the right of cross-examination. That was refused. Inspection, I had to ask 3 times. I gave a preliminary reply. I gave another reply. Lord, then why doesn't, I ask myself this question, Lord, why doesn't the adjudicating authority deal with my reply of 6/2/2019 to the show cause notice, where I have taken this down specifically? He could have said,
Take us through that.
yes, I'll take you through that. And this is what, Lord, this is what SEBI has given us.
An inspection.
From the inspection. But let me just give the figures. For the moment, everything that Mr. Pava says, please accept it. But please see the data, and after that, I'll come back to that also. Please see.
No, we don't want to accept it if you're prepared to deny it.
Sorry, Milord?
If you're prepared to deny it, we don't want to accept it. Is it correct that what was annexed was a DVD and not a sheet of paper?
Given this log at 148, it's in the original file. Which is why I said, Milord, please look at my reply to the show cause notice. Correct? Let's just go that. I'll give these figures later. Just show me. Volume 2, Milord. Milord, 378, volume 2, Milord. This is part of the reply, Milord. Sir. Annexure 8, Milord. Now, this is my second reply, Milord. Come straight away, Milord. Page 386. Para 34, Milord.
Yes.
Yes. Can I just read this, Milord, a little slowly, because this is also referred to in the SAT appeal. In the investigation report and therefore the SCN and the inspection documents, the following information, which forms the bedrock of the investigation, renders the appointment of the adjudicating officer untenable. The information in the table at page 605 of the investigation report is factually incorrect, is contrary to the information purportedly supplied by NSC to SEBI by letter dated 10/12/2014. The said table is materially inconsistent with respect to price and volume, which is quintessential for a case to be made out under. These are those PFUTP regulations which your lordships were taken through yesterday. The source of information used at pages so and so of the inspection document is not disclosed. My lord, I asked for the source, I was not given. Please underscore this. If everything was hunky-dory, they should have given me the source. Because, my lord, it's a very serious allegation that I am indulging in fraud and unfair trade practice. As I said, my lord, it will bring down my share value and a lot of investors will suffer. Yet it is evident that the same is contrary to information data under the very same head purported. Now, my lord, these are the two entries at D I showed my lords yesterday. For example, in the table in respect of entry dated 17/2/2014, the quantity available for sale at or below 335 is mentioned as 1,31,15,865. However, the sell quantity below so and so as per data for the same date is shown as 30,01,484. In other words, SEBI has inflated the available sales side book that could be said to be available to absorb purchase orders placed by company over 1 crore shares. This falls in an inaccurate picture, suggests that such a huge supply was available in the market, but the company did not place its orders on the demand side. Such inaccuracy cuts to the root of the matter. Over the page, my lord, again with respect to the second entry, 14/2/2014, it is mentioned that the quantity available for sale at or below 135 was shown as 1 crore 24 lakhs, etc. But as per NSE, on the same date, such sell side order book was only 36 lakhs. Again, an overstatement of supply side by nearly 1 crore shares. Similarly, BSE table on investigation entries dated so and so onwards up to 22nd July 2014 show, this is between May, my lord, this is the period, the lowest price of CIL shares for stock was much above 335, which means that on those dates, price was never 335 or below at BSE. However, in the corresponding entry in the investigation report of so and so, it is mentioned that there were 3 sell orders. Lord, why would anyone? And there were sell orders available at or below 335. Correct? Not such blatant incoherence and inconsistency in the figures of price and volume, coupled with not even extending courtesy of etc. My lord, this is some reasonable man, ability for reasonable man to form a reasonable opinion not being existent. Therefore, the very initiation of these adjudication proceedings is unsustainable. Now, my lord, this is about H is about buy orders. CIL merchant work bankers, we did a letter dated so and so, to has evidently informed SEBI about the buy orders placed during the buyback period. For review of the first few entries on 3/2/2014 and 4/2/2014, the buy orders placed on NSE were 10,86,000 and 25 lakhs 76,000 shares. However, as per the table in the investigation report, the CIL has been the buy orders placed by CIL have been understated vis-a-vis 8,67,000 and 10,51,000. This implies that the differential between buy orders and sell orders, which SEBI is using to show fraudulent activity, is overstated and incorrect. While sell side of the orders have been inflated, that's the burden of this discussion.
So, as against these figures,
Yes.
what did you point out to the SEBI?
My lord, I
say, for example, 1 lakh and 1 crore and 31 lakh and odd, 1 crore and 24 lakh and odd. According to you, these are all inflated figures.
Correct, my lord. So
this was not the position on that day.
Yes, and
what is the
now
data which you put forward?
My lord, I won't have the data is, my lord, with the boroughs. My lord, the data is with the stock exchange. As to, my lord, I don't know there are how many sell orders are there. Now, I would know only about my.
The basis for you to dispute these figures.
My lord, the basis is this. SEBI is saying I am using the data from stock exchange, which the merchant bankers are given. Lord, they are certified merchant bankers. They are registered with them. If they give them false data, my lord, they are liable under the code of conduct. They take no action against the merchant bank.
Mr. Shakdar.
Yes.
This is what we have understood. The allegations are that on 17 February 2014, it was possible for you to sell 1 crore 31 lakh 15,865 shares within 335. The price is 335, right? What makes you say that in fact on this date, it was not possible for me to sell these shares?
My lord, can I just put this in perspective? Because, my lord, we must, my lord, the perspective is this. And you
because when you have declared that I want to sell the shares, you must be keeping a watch every day.
Buy the shares.
Buy the shares. You must be keeping a watch, right? Whether these many shares are available or not. So how do you keep that watch?
No, I'll tell my lords how. I have two answers to this, my lord. One is, my lord, that's a broader picture that your lordship will bear in mind. What is a buyback at the end of the day, my lord? The company, as Justice Vishwanathan also noted yesterday, you have surplus cash, my lord, and reserves. Now, typically, my lord, as I said, Trevor versus Whitworth says, company should not buy its shares. Why? I'm sorry, my lord. You are also looking at the interests of the creditors, because it's the fiduciary duty of the directors to maintain capital and preserve assets. You can buy back shares, and this started somewhere in 1980s all over the world, my lord, only in accordance with the statutory scheme. The statutory scheme is in the buyback regulations, the Companies Act. Now, when I go to the market, what is my fiduciary duty to my shareholders? My fiduciary duty is, I go to the board of directors, they say, okay, the shareholders back it, and they say 5,000 plus crores is available as I call it, my lord, the cash that you can spend. Two, that you will not buy more than 335. Two things that your lordships will not bear in mind. That's my respectful submission. The directors are not supposed to buy, they need to economize the war chest, as they say have. They have to buy at the lowest, because the moment I buy more, the reserves get low. But I have to keep in mind their buyback regulations. Their buyback regulations say, as they stand today, is that you have to buy minimum of 50%, and there is an exception. And if you don't buy 50%, then the escrow amount of 143 crores that I gave, and I also gave a bank guarantee to cover the. I will come back. I'll come back to that. Milord, I'm not. I'm just giving a background because it is construed as if SEBI determines, and there is case law on that, as to when I will buy, how much I will buy.
No, no, no. The moment you point out to us,
yes,
these figures are absolutely imaginary. It was not possible for us to buy the shares on so and so date, as these shares were not available for the purpose of buyback.
Lord, what I was showing is the Lord. First of all, let's see this what I pointed out in my reply. How is the AO dealt with it? How is the AO dealt with it? Is that paragraph?
A bit. What brother is trying to say is, in that 6 month window, you are bound to closely watch and take an economically viable decision for you, which is in your best interest. Look for the lowest price also, and keep other parameters like not creating an artificial boost, etc. But there will be a record of the day's decision as to what was on offer, why it is considered unviable. Though the initial burden may not be on you to discharge that, we can't just close the matter by saying the figure shown by him, there are some discrepancies, and leave it at that without getting to the actual figure. Either we have to ask the NSE, or you should have shown something as to what exactly was your minutes or your noting on a day-to-day basis as to why a decision was taken. Because his point is very simple. If his data is correct, which you are now clearly showing is wrong because there are large mismatch, that NSE, where there was regular trading prior to the buyback commencement, the offer of shares and the offer to buy and the availability, there is a mismatch. Whereas BSE, the offer to buy is more and the offer to sell is less. You're clearly saying that on 14th of February and 17th of February, large disparity in the rates. His answer is, look, the document that you are referring to is not even part of the annexure of NSE.
Correct.
He says DVD was the one, and he says that chart which was mentioned in para 48 of this SEBI order is the correct figure.
So, my lord.
So the best way for you to dispel is what brother is saying.
What Justice Padiwala said, Lord, I'll come back to that. But when I started this, I said I showed something in my reply. I took these grounds. Now see the AO's how the AO deals with it, my lord. Please,
You prayed for extension also.
Yes, I did.
That was declined.
That was declined, my lord.
You didn't take any further steps against that.
My lord, they are the ones who give me that permission. My lord, in 68(4) there is that power. Please see that of the Companies Act. Why not just see that for a moment? It could have gone to 12 months. If I was actually not a serious charge, 68(4), my lord, just show me the Companies Act. Earlier it was 77A. Every buyback My lord, your lordships have seen 68.4?
No, we didn't get that. On the 13 Act?
Yes, my lord, 77A is the old provision.
77. Now
Yeah,
it's
but 68. 68, the heading, marginal heading is power of company to purchase its own securities, but goes straight to subsection 4. My lord, has that not? Every buyback shall be completed within a period of 1 year from the date of passing of the special resolution, as the case may be, the resolution passed by the board under clause B of section 2. And then
What
they
is
say,
the price of the share after the expiry of 6 months?
my lord, it was hovering around 340 or so. I'll show from the one.
340.
So, yeah, so my lord, it wasn't, in a sense, I gained and I gamed the stock market. You know, I'll show from the data, because what was put to me is, if you
Obviously, it was not in your interest to take extension also. That's why you didn't challenge. If there was a similar provision to 68.4 in 77, I'll take it the 77.4 or something would have been there. So brother said, because I am entitled to an extension or entitled to be a fair consideration of the extension.
No, my lord, my lord, then SEBI can put everything against, my lord, that's very hypothetical. I asked for it.
We must know what is the correct figure.
Correct. Now, my lord, two things I'll show to my lords. First, please go to 6. Okay, my lord, please go to 6, page 643, my lord, of the reply volume 2, where my merchant bankers gave the data and they have accepted it.
643,
my lord.
And
Just before you go, just 37 of this one little bit. 37 of your reply.
The show cause notice.
Yeah, what is the reply?
Yes.
Page 388. What is this investigation report?
My lord, there are 2 investigation reports of there. They say I have not. Huh?
No, just see 37.
Yes. Para 37, my lord?
Yes. Thus, in the absence of the data,
contained in the said 2 tables, the allegation of violation of so and so could not have been made in the investigation.
Investigation report and in SCN. So there is some investigation report where they seem to have found about some violation. See your own reply.
Yes. My lord, why? What I was relying upon and what they didn't show either in the list of dates yesterday, there were 2 reports before that, my lord. One was of...
Before this report?
Yes. Their own report.
One we saw, one you showed.
I show you the other one. The legal department said when the consequences of buying less than 50%, which is provided in 14.3 of the buyback regulations, is provided in 15.8b, then you cannot mulct them with this kind of penalty. Please see, my lord, with this kind of penalty of 5 crores for alleged fraud. But as your lordship said, I want my lords to see 643, because your lordships asked me a crucial question and I must answer that. What did we do? And there is no show cause notice issued to the merchant bankers, my lord. If this data...
647?
643, my lord.
PDF is +4.
I'm sorry. Yes. My lord, this is addressed by my merchant bankers rather, my lord, Standard Chartered and Morgan.
PDF.
Yes, my lord. You know, the subject is buyback of fully paid, etc., etc. This letter is in continuation of letter of 10 January 14, so and so, in relation to the aforementioned and subsequent discussion with you. For the purpose of wishing this, we've reviewed and relied on the following. Data inputs provided by stock exchange, that is BSE and NSE, on the number of shares traded at each price point on the days on which the company had placed buyback orders, data provided by Axis Capital and Morgan Stanley, the brokers through whom orders have been placed by the company.
So what is this exactly?
Milord, can I just read this at 644 and then I'll come to 645 and 649 where this data has been provided. 324. Yes. Now, Milord, at 644 it says, on the basis of the review of data, inputs provided by stock exchange as mentioned above, trade execution, merchant banking certified that during the period 23rd January to 22nd July 14, the days on which orders were placed, corresponding sell orders at or below company's limit price were inadequate, please mark that, my lord, to cover the number of shares for which buy orders were placed. This letter is being provided pursuant to Regulation 15B8B of the buyback regulations. Now, my lord, please see the data that they supplied.
Now, just a minute. Yours truly Standard Chartered Securities?
Yes, my lord.
Then
Morgan.
For Morgan, who are these two?
My lord, these are my merchant bankers, my lord, and the persons that were engaged.
So you would place orders with them?
No, they would place orders.
No. How would you get in touch with these two companies?
My lord, I give them that mandate, my lord, that I'll show.
That I want
Through
to
email.
buy back these many shares. These two companies in turn will do what?
My lord, then they will go onto the platform, my lord, stock exchange, and execute the trade, my lord.
And they will be the conduit for the purpose of buyback of the shares. And you have to pay some commission to them?
Some small commission is there, whatever the commission is.
So according to the Standard Chartered and Morgan Stanley, during the period 23rd January 14 to 22nd July, the days on which orders were placed by the governor, sell orders at or below the company's limit price were inadequate to cover the number of shares for which the buy orders were placed. That's your principal argument.
My principal argument, and this data, Lord, please see the data is given with this, was accepted. Lord, I could have understood. They would have said.
Ek minute, who gave you the data? These two?
No, my lord, they asked for the SEBI asked. This is addressed to SEBI by the merchant bankers. Please see 643, my lord. At the top, Ms. Divya, SEBI. And they had been corresponding. Does my lord have that?
Yes.
It is addressed to SEBI.
Standard Chartered and Morgan has addressed it to SEBI.
Yeah, because they asked, my lord. And in continuation of various letters, in the first part, your lordship would see, this letter is in continuation of our letters.
This says we have reviewed the data.
Yes. And then given the data also, my lord.
So the merchant bankers are giving the data.
Yes.
So data inputs provided by stock exchanges.
Correct.
And national on the number of shares traded so and so. Now, this is the annexure you are disputing.
No, but this is the annexure which their agent sends to the SEBI containing data of the days when the orders are placed. So, that is with respect, not the controversy. My friend is showing something which is not the controversy. They placed orders on days when the market was not favorable. And the data which they are producing.
Data for the
Yes, kindly see. Days on which company had placed the orders. So that is, our contention is the days when the orders were favorable, you don't produce the data, my lords. My friend, with all respect, shows something which is not relevant for the present proceedings.
So, Baba, I am facing some questions and I'll answer this question. Please see 649. My lord, for a moment. 649 and compare it.
January 22nd. But then
I can show that document.
He's relying on the data.
Yes, lords.
Furnished by stock exchange.
Yes.
So
Can I?
they must have furnished for other dates also.
Yes.
It means.
Yes, certainly. Can I just take you?
So, Baba, if you don't mind, because it's breaking my chain of thought, I didn't interrupt you. Please, if you don't mind. Lord, please see page 649. And please open
649.
My lord, couple of pages down. PDF 653, my lord.
Mr. Lahoti, your turn will not come today. Some other date.
First and foremost, I am grateful to you. 6 November, I will always remember. And both of your lordship had accommodated and
But you didn't go, you came back in the afternoon.
I'm in item 120 and 122. 122 is a home buyer's case, my lord. That is why I was thinking if your lordships can.
122.
Yes, 122 is home buyers. 120 is 269 UD, that preemptory right of CB Gautam, my lord, the 5 judges of this court.
Yeah, home buyers wali matter up top of the board.
Yes, 122 if
Next Thursday. Okay.
Grateful, my lord.
Yes.
Just one second. My lord, would your lordship see 653 of your PDF file now?
53.
653. No?
Yes.
It's the heading is annexure to access buyback orders. Now against 3rd February, NSE is there, my lord? Correct?
Yes.
The buy order is 10,86,026.
653?
My lord, PDF 653, but otherwise running page 649.
Yes, yes, you give running page 649.
Yes.
Yes.
NSE, my lord?
3rd February. Yes.
3rd February 2014.
Yes.
10,86,000 is the buy order as per this data.
10 lakh. That is 4th February.
No, 3rd February, my lord. First row, my lord.
3rd February is 649.
3rd February, my lord.
3rd February is 10 lakh 86.
Yes. Also keep in mind, 4th February, it is 25 lakhs 76,000, again buy order. Then 5th February, I'm just giving couple of entries, 18 lakhs 6,000. It is 18 lakhs 6,773. Now please see page 59 of the adjudicating authorities order.
Yes.
In the civil appeal. Keep this side by side. And this data I will show, they have verified and accepted it. Page 37 would show. Does my lord have that now?
Yes. 59.
Now please see 3rd February. They show buy order of 8,67,000, whereas it's 10,86,000.
Obviously, there is discrepancy.
Now, not one or two. I made an entire chart. Now today say you are fudging at this stage. When the AO could have said the same thing, it notices my letter of reply of 6/2/2019. Please see, my lord, all these entries that I just showed, 3rd February, 4th February, 5th February. I'll show more. But please go to page 37 of this very paper book. And my lord, your lordship would also see the reasons for remaining orders price did not match. Does my lord also see at 649? Why orders were not executed, correct? My lord, because suppose I say 321, correct? Someone says 321.10 paisa. And they are assuming that I am the only buyer in the exchange. My lord, this is based on statistics, which you can interpret whichever way you want. But please go to page 37, my lord, of this appeal paper book. And this is not my data, my lord, as I said. Please go to page 37, my lord.
11 June.
Now, no, first, yeah. My lord, this investigation report, strangely, was not in his list of dates. But I think that was...
Now, you kindly 46, which is set, I can ask 147 of your additional volume.
Of this very volume, Lord? 147, no. Just give me the other one. Yes.
If you see the letter of National Stock Exchange addressed to SEBI.
Yes. My lord, it says both things. It says DVD containing trade and order log as per your request.
Order log as per your request.
Correct.
Now, this you say is the annexure at 147.
Yes, my lord. 140.
Your data is drawn from this log.
Yes. And the merchant bankers. My lord, forget about me.
The merchant banker.
My lord, I'm saying forget about me. I'm not even in the picture.
No, first, unless we determine which is correct, or if either of them are wrong, which is the correct data.
So the easier thing is, your lordships are right, my lord. Please keep this aside for a moment. Please see page 37. Did they verify it or not? Because they are now debunking.
It's not both, Mr. Shakti, subject to correction.
Sorry, my lord.
Please find enclosed the DVD. And the DVD contains what? The trade and order log as per your request. So the DVD contains both. Otherwise, it will not make sense, that line.
Lord, I have got it. This is...
They're not disputing. You may be right. They may be wrong. They will, for us to have closure of this.
Yes.
Your entire figure is drawn from this, where you are showing discrepancy on 3rd February, 14th February.
And what I showed at 649.
Now, which is correct?
No, that's why I'm saying, my lord. So therefore, they did an internal investigation. That report was not shown to my lords the entire day. Please go to page 27. They can't debunk their own reports, my lord. Please see page 27.
See to tell us, BSc to tell us whether it's true that was correct, whether it was
Print we have 37.
Additional diary?
No, my lord, the first volume 1, my lord, of the reply, that has the first report, their internal investigation report.
37.
It starts at 27, but comes straight to 37, my lord.
Conclusion.
Plus, I mean, not 27
The
was.
discrepancy in the two dates is very large. So we have to, one of them have to be correct,
Yes.
or both of
No,
them.
but then, my lord, please see, how can the onus be on me when they say, my lord, please see page 37.
We will have to check out.
Does my lord, have your lordship seen that, my lord? 8.15?
Except that if you had the minutes and said the best way for you to show will be that, look, this is not correct.
My lord, they always go to an independent source, which is the stock exchange and the merchant bankers, because they are bound by a code of conduct. Because if this is a serious thing, they should have issued show cause notice to the merchant bankers. I had given a bank guarantee of 1,228 crores, apart from 143. Now, please see this report, my lord, at 8.15. Just
8.15
para. It's
page
37. I had 5.
Of the additional volume.
Of the
additional volume. And annexure?
Annexure 3, my lord. Annexure 3 starts at 27.
You want to have a look at 30?
First, see 27, my lord. This is their report on this subject. My lord has that.
Just a minute.
The subject says, sorry, does my lord have that? It says the subject at the top, my lord. It's a SEBI report. Investigation in the matter of suspected non-compliance with buyback of its shares by Kane. Investigation in the matter of suspected non-compliance with buyback of shares by Kane has been carried out. Copy of the investigation, etc. And under the signatures of Mr. Sujal, 11 June 2015. 5 members.
Now, what do you want to read from this?
Yes, I was showing, my lord, page 37. Apropos to what fell from my lords, the merchant bankers' data.
37.
Yes.
Read
Can I 18.14?
Yes.
8.14. This one. Actually, the whole thing is important, but for the moment, I'll straight away go to 8.14. The merchant bankers with the buyback informed that for providing aforesaid certification, they relied upon the following information: data inputs, stock exchange, BSE, etc., on the number of shares traded at each price point on the days on which company placed.
So they also must have been summoned by the committee.
No, my lord.
When the report says,
yes, my lord,
merchant bankers for the buyback informed. Informed whom?
Informed them, my lord, SEBI. Not
He's saying this para also only says for the days on which
No,
orders
not-
are placed.
Please see 8.15.
On the number of shares traded at each price
Point on the days
in the days on which company
had placed buyback orders.
buyback orders.
Correct. Data provided by Axis Bank through brokers through whom orders had been placed by the company. 8.15, this is their officer, investigator saying, the statement made by merchant bankers has been verified and found to be correct. Hence, it is found that Kane has complied with the relevant provisions, that is, regulation so and so. They verified the data. Then, based on the findings above, in paragraphs, my lord, because in paragraph 8.13, your lordship would see, and this is an important marker, my lord, in that box, BSE volume weighted average market price was more than 335, it was 348 for the whole period, because that's their marker. If you cannot do 50%, but the volume weighted average price is more than the maximum price, then you can't be docked, which is why they released my escrow amount of 143 crores.
Now, just a minute.
Yes.
Come to 8.16 at page 37.
Yes,
Based on the findings of above, para 8.12, 8.13, it is recommended that the matter may not be pursued further.
Correct.
Then what is annexure 4?
Now, annexure 4 is the other report.
So why there were 2 inquiries, 2 investigations?
Because they just didn't want to release the money to me, that escrow amount of 143 crores.
Now, tell us in what manner these 2 reports are in conflict with each other.
These are not. There is a third report after 1.5 years in March of 2017.
So, annexure 4 concurs with annexure 3?
Yes.
Let us see the last part of it.
Yes, please see this. Lord, an extra of 4, and your lordships can mark the date is at the end. It's 3/2/2016.
What is the last page of this report?
Last page of this 49, my lord.
49.
Yes.
Let us see.
8.20.
8.20.
The escrow account is exempted from forfeiture under clause so and so, as case was initiated upon receiving reference so and so, so as to, as suspected by during the same is being investigated separately. What do you mean by this?
My lord, yes. The answer is, first of all, my lord, please see, could my lord just...
So 37 said, close it. 30, the second page, 49 says, suspected violations of PFUTP, same is being investigated separately.
Correct, my lord, but the data that was, there are two answers to it. Your lordship said, is the data suspect? My answer was...
Your argument, your reply is, data was accepted.
Accepted, verified. Correct, my lord? And their investigator.
Third report, the final report, it declined to accept that data.
My lord, the final report, when the show cause notice was issued, I raised the very same issue. I showed that 6/2/2019. The adjudicating officer records a lot of submissions, but doesn't deal with that aspect of this, the mismatch in the entries. But please see this. Let me just come.
Where is the third report?
Lord, the third report is this. I'll give that also.
750.
Before that, my lord, there is a internal. My lord, now please see 757, my lord. My lord, you can, no, before that, my lord, page 50. I'm so sorry, in the same file where your lordship was looking at that. Page 50.
What is 50?
My lord, this is SEBI's direction to the merchant bankers. Please now release 143 crores. My lord, I would have thought a reasonable man would say.
That is because 158.8A says you can't forfeit an amount in escrow. Is it correct?
It says you cannot. Why? The exception is if the average weighted volume price is more than the maximum price, which is what is given at page 49. Just a page before. So, for situation, there are so many of these where you don't complete 50%. You don't jump to a conclusion that this is a fraudulent transaction. Because there are so many ifs and buts. For example, my lord, this is May 2014. Why was the stock exchange, my lord, bullish? One of the reasons could be they were expecting the change in government. They were thinking there is a government which is going to be more pro-investors. My lord, the sentiment can be on any basis. 22%. Now, please see, my lord, page 49. And this is an important parameter, my lord. Volume weighted average market price for NSE or for BSE was 348.10. For NSE was 343.11. It was above. And now see the regular, and then now see page 50. So, in July of 2014, they carried out 2 investigations.
Now, what will be the effect of 8.20.1 at page 49? The escrow amount is exempted from forfeiture under clause 15 capital B subclause 8 small a of buyback regulations. What will be the effect of this?
Lord, the effect of the Lord, they have used...
As case was initiated upon receiving reference from CFD DCR, we may inform CFD findings of the investigation.
Yes, Mr.
So as to enable them to proceed further in the matter.
Yes.
And then all of a sudden it says, same is being investigated. So fraud was being investigated separately.
No, my lord, the data is the same. They are alleging.
Maybe. There were 2 simultaneous committees.
No. First, this happened. These 2 investigations happened. Then there was an opinion sought by from the legal department. Lord, he is going to deride his own. My lord, can I
come to just a minute?
Yes,
Mr. Shakt. Come to para 49.
Yes, my lords.
Page 49.
Page 49.
Yes, my lord. 8.20.
8.20.1.
Yes, my lords.
8.20.2.
Yes, my lord.
What is this 8.20.3?
Yes, I'll answer with permission. My lords, 8.20.1 investigation outcome is only for the purpose of deciding as to whether under regulation 15 capital B of the buyback regulations, I am supposed to forfeit the initial 2.5% deposit amount made by them or release the said amount.
Now,
in their favor.
when are you entitled to forfeit it, Mr.
Yes.
Power?
My lords, regulation 15B provides for the parameters in which case I can forfeit and in a case where I cannot forfeit.
If your case is one of fraud,
Yes.
should you not have forfeited
My
the
lords, the submission to my
escrow account?
the submission to my lords is this, that in regulation 15B, there are defined parameters and that is based on weighted average price on the given dates. Now, my lords, I cannot travel beyond the regulation because it's statutory.
Fine.
So
Come to 8.20.3.
Yes, my
when the committee says,
yes, my lords,
as regards suspected violations of so and so,
my lords,
same is being some parallel
yes,
investigation.
my lords, I'd like to submit this to your lordship's court, as I urge for kind consideration of your lordship court, for the purpose of determining release or forfeiture of the escrow amount. I'm governed by regulations, so my decision has to be based solely on the parameters defined in the regulations. I cannot travel beyond it. Now, my lords, the legal department, based on the information received from the stock exchanges, found that the whole transaction suffers prima facie by fraud. Now, my lords, investigation of fraud is done by a special team within the SEBI. So, as regards escrow account is concerned.
But they looked into the very same data?
No, my lords. For the purpose of 15, this regulation, escrow account, my data will be limited to the requirements of regulation 15 capital B. I can show my lords the regulation. So I have to only keep in mind the defined parameters in the regulation to determine whether I can forfeit the amount or release the amount. For the purpose of fraud, my lords, I travel beyond this data.
My learned friend is.
Please allow me now.
One second. Travel beyond what?
Travel beyond the data which is necessary for the purpose of determining whether I should release the amount in the escrow account or not.
Correct.
My lords, kindly consider.
So what is that additional material?
Yes, my lords, I'll answer.
That your legal department looked into for the purpose of bringing the case in the purview of fraud?
Yes, I'll answer, my lords. My lords, please consider the third report, the report made after this report of 17th of March, is the report which exhaustively discusses
that
additional
is
data.
Annexure?
Annexure A12, page 757, which my friend has not shown to Lordship Court until this time.
Reach there, Mr.
No, but you're not gone to this place.
We
Very well. I'm sorry. Annexure 8, Annexure 12, Lordship may consider. Page 757.
Yes, yes.
Please consider, my lord. This is the investigation report to detect the fraud and based on which the show cause notice came to be issued to my friend's client. May I request Honorable Court to consider some parts of this report if I can fix it for consideration. Lordship may see the scope, my lords, of this report. Para 1, Honorable Court may just kindly go to last subparagraph of Para 1. As regards suspected violation. So earlier reports were based only on Regulation 15B, which is up to Para 3, well, subparagraph 3. And subpara 4 is saying, as regards suspected violation of buyback regulations, the investigation did not find any violation and the report in this regard was already put up and approved in February. As regards violation of PFUTP regulations, it was decided to investigate the same separately and accordingly the report deals with the same. Then, my lords, pursuant to the investigation of the IRD, following is noted, this report, my lords, is an exhaustive report. And my lords, I would just show my lords the ultimate discussion. Honorable Court may see page 772, para 8.12 is the conclusion. This considers large number of data which was shared with them in the show cause notice and to which the reply was given and it was adjudicated upon. 772, if I can place it for my lord's kind consideration.
Not convenient reading of the report.
I can read the entire report, my lords. I have no problem, my lords.
Just a minute.
data that. Yes.
It's 5 minutes. 5 minutes.
Project. Okay. Data आपकी फाइनल डेटा दिया है ना एक है हमने को लगा है वो डेटा नहीं मिलेगा इसका कॉल करें इन्वेस्टिगेशन हमने थोड़ी बना लिया है हमारा डॉक्यूमेंट ही नहीं है हम इनका केस डेटा गलत है हमारा
Mr. Pava, you won't represent NSC and BSc, no?
No, my lords. But can I just assist Honorable Court with one aspect?
Where is the DVD log which?
Can I just show? Can I just two things, Lordship, just kindly consider? I just answer immediately on the
This
DVD.
takes us to the log.
I'll answer immediately.
Because it again says.
My lords,
put
I'll
a border
answer.
on NSC.
I was wanting to answer that. Two things, Lordship, may kindly consider. This communication at page 147 was discussed in the SEBI in 2022. Internally, emails were exchanged as to whether this chart, is it part of the DVD referred to at page 147 or not? Department has said categorically in 2022, DVD does not consist this chart.
Then we can't go by that.
Two things, just one more thing. In the SAT, my lords, my friend took this very contention in the appeal. In response to the appeal filed by him in the SAT, we filed a counter. With the counter, in SAT, we have placed email communication of NSC. That email communication contains a chart of all transactions.
Which matches with the.
Yes, matches with page 58.
Adjudicating authority.
Yes, directly. I have the entire reply with me, my lords. My friend, with all respect, my lords, I have on record the documents. Lordship, just can see the reply filed by me in the SAT. It's on record. May I request Honorable Court to consider to refer to, my lords, my friend's contention first, my lords. My lords, his appeal, ground G, page 92. My lords, with all I'm sorry.
Where you annex the NSC's.
Yes, it is there, my lords, page 176.
Furnished after the adjudication?
After the adjudication.
But what is the DVD saying?
But DVD, my lords, I don't have that DVD here right now. But DVD, my lord, can I show that page 148 for a minute? Lordship may itself find that it's not part of the DVD.
148, the reply which you are saying now, show that.
No, but can I just,
My lord,
147 for a minute, but 147, even Lordship may see, my lords.
What is that?
No, but it talks about data from NSC stroke BSc. It is not there, my lords. It can't be there. NSC giving an email to me. Kindly consider, my lords, page 147.
Different organizations.
Yes, my lords. I have sent different email communication to BSc and the NSC. How can the NSC tell me data of BSc, my lord? This is not possible. And two, my lords, the language used is number of cell orders. My lords, two things are different. The cell quantity is different than number of cell orders. My lords, may I just in a given day, there could be 100 sell orders consisting of 1 lakh shares. Where one order is, let's say, 500 shares or 5 shares or 10 shares.
Different from what is placed for sale.
Absolutely, my lord.
Taken.
Not the quantity, not the number. Suppose Naveen Power raises one order, but Naveen Power raised one order.
Lord,
Just
sorry.
We will now discuss as if some common man is trying to understand.
Yes, ma'am.
Mr. Shagdar, come to page 772.
717.
772. The conclusion drawn by the investigating committee. Para 8.12.
Yes, ma'am.
Kane was putting buy orders in BSE, where volumes were far less, whereas Kane was required to buy more than 50% quantity in NSE to achieve the buyback size. This is evident from the following. In BSE, on the favorable days, sell orders for only 2,45,93,723 shares were available, whereas Kane placed orders for 4,33,38, understandable. On the other hand, in NSE, on the favorable days, sell orders were available for 67, 50, 91, 575, whereas Kane placed buy orders for 3, 36, 17, 210. How would you make us understand this?
Yes. Lord.
Now, when you decided to buy back, you were supposed to buy back from BSE also and from NSE also. There's no difficulty in this regard. You are expected to achieve a target, whether you buy it from Bombay Stock Exchange or a national stock exchange. Are we correct in this regard? Right? So, all on the favorable days, when sell orders were only 2 crores and odd, your orders were exceeding 4 crores. On the favorable days, so far as NSE is concerned, 67 crores were available, but your orders were for only 3 crores. That's the simple point.
Yes. Lord, my short answer to this is, I do not know who was selling and what price was he indicating. Suppose my price was 320. Correct? The seller wanted 321 or 322. The price didn't match, it didn't go through. One. The other is, when they level, and this is again an answer to my lords, a broad answer, the allegation is fraud that I never intended to complete the buyback. To which I say, my lord, you have to take both the stock exchanges together, because when a seller goes to a stock exchange, my lord, he sees what's the position, what is the price I'm getting at NSE, what is the price I'm getting at BSE. He can opt for any of the two. One. Two, my lord, my learned friend, I'm just going back to what my lords were asking about the third report. What was the focus of the first report? It was also these unfair trade practices regulations. Please see page 39 for a moment. Volume 1. My learned friend is wrong when he says...
Are you disputing these figures also?
Lord, yes.
In para 8.12?
Yes, yes, my lord. I'm saying so. Therefore, my lord, what I just one second. What I wanted.
Are you disputing them?
Yes, my lord. They are custodians of the data.
What first blush, excellent answer by you that we don't know what price the seller put. That's not may not be correct because if you come to the chart, even the sell side is at or below 335.
Could be anything.
You see the chart.
No, my lord. It has to match.
See, it is matching. The figures which brother read from conclusion.
My lord, your lordship will have. No.
1 minute. Seller could have asked for 340. I know, I showed that. Very good answer. But the chart says it is also at below 335. Seller is also saying. So the 67 crore figure is below 335. Just keep it in mind. You may be right. Maybe the seller would have ordered more, but when we checked up the page 62, sell side is also at 335. And the conclusion drawn in the third investigation, which is the real issue, that market, you see how it operates. Moment there is a buyback.
Yes.
There's a feel good and there is a positive factor.
Yes.
With resulting in buying and selling, maintaining the price at a high level.
Means.
That is the only difference between stock market fraud and the normal fraud.
50 seconds. Yes, my lord. I follow what.
You know, small board leaks are treated as price sensitive information and then proceeded against under the regulations because they have a tendency to one day and then the price you see shoots up, you pocket it and then you that's the thing they want to
Lord,
valuable customers to
No, I also want my lords to keep in mind this perspective which I started with, my lord, that I am, as my lords put it to me also, trying to economize. But see page 252, my lord, of volume, my reply, volume 1.
We'll come back at 2 o'clock. A little of skating and then we'll start with your. You understood what we said?
There is a skating federation matter going on, not your, nothing to do with your matter. There's
I
a
don't know,
2
my
o'clock.
lord. As long as skating and I'm not sliding.
And there is a 2 o'clock skating federation national games matter. Yes. That won't take.
You know, there is a particular price. I just wanted to show when
Yes.
I mandated the merchant banker, particular price at 252, please.
Yeah.
That in mind.
I'm seeking my lord's permission to mention a matter which is coming off tomorrow, my lords, as item number 3. I'm
Tomorrow. Mention it tomorrow.
My lords, we have filed the counter affidavit in this matter, my lords. My lords, may kindly direct the registry to
Have
take
you
it on
not
record.
read the recent circular? You're not supposed to mention. Then someone will blame us.
My lords, counter has been filed, my lords.
Correct, but then there are ways and ways of placing it on record. Place it on record.
My lords, may kindly direct the registry to place it on record, my lords. We have filed after it. Grateful. I'm so grateful, man.
11. So I appear, Lord, had asked the learned solicitor.
Where is he?
Malad, he apologizes profusely, Malad.
He is also participating tomorrow. Huh?
He's doing his case. He's on his legs in another matter. Malad, I apologize profusely. I was on his behalf. Malad, we were.
So what are your instructions?
Malad, we have written instructions. Malad.
Let us see.
And then we have a little further suggestions. Malad, we'll see our note and then the joint secretary is here as well, Malad. Nine and 11, Malads. And then, Malads, I have two suggestions on that.
Copies in black and white.
Ask me to come this side. It's para 9 and 11. Malads, I have two suggestions based on that.
What are your suggestions?
Malads may be inclined to ask them to have a special general body meeting as a one-time measure to place the issue and solve it. That's one. So we're not taking any sides.
How are you all going to work? How are you all going to run this federation when the office bearers themselves are fighting in interest?
Can hold it under maybe the registrar of societies and video record the meeting and then that sort of, because we are interested in ensuring that the event takes place. It's an autonomous body.
Yes.
Order of the High Court yesterday.
Yes, yes.
There is.
Lord, the collector's report may be useful on the basis of which this order was passed. It
Or
has the whole photographs.
The second suggestion is, Malaj, if the place is whatever is ready, then Malaj, it can be timeline for participation for the participants can be extended, and maybe some more time may be given.
Lord, may I just assist?
We wanted to know from you.
Yes, Malaj.
So where is the order?
The order is already placed.
No, it's not with us.
No, before the.
Lord, I will hand
Since
over
the
the order,
order has
getting a
been
copy of
subsequently-
it.
Where is this stadium situated?
My lords, this is in Vizag. I just assist my lords here. There are a total of 6. The first one, lordship, said internal page 3. Lordship may just see this is, can my lords just take the last page? It's by the collector. The last, lordship is seeing the order. There's the order. इनको भी दे दो that affidavit. It's that.
So the General Secretary wants this event to be held at which place?
Vizag.
And the President?
Wants it outside there.
Where?
He first tried for Karnataka, the state refused. Now he says for Tamil Nadu.
My lord,
He's playing.
I have taken instructions. But according to us, my lord, whether the stadium is complete, whether the pitch, etc., my lord, is complete. This, my lord, the collector cannot decide.
Of course.
Are you, Mr.
Lord, I am the president. I am the for the president, my lord.
President and General Secretary?
No, my lord. What we are saying is we are, my lord, we are amenable. My lord, let the, my lord, event be held at a time, my lord, when the stadium is complete in all respects.
That is precisely.
But it is ready.
My lord,
एक दिन बात करें.
now, please see the union's last paragraph. Several players and state associations have sent emails to the ministry requesting for deferment. This is what not the majority of the associations don't want to come here because it is not ready. It's a safety hazard, my lord, because the rink which is involved in roller skating has to be, my lord, of a particular technical. They are even painting it today, my lord.
You want all the participants
Yes, my lord.
who have reached Vizag.
My lord, I'll tell your lordships.
To go back.
Lord, what has happened, my lord, I'll tell, my lord, I have taken instructions on that.
My lords, I have written instructions of 2,379 and
Out
even,
of 30
no, 1 second, Uttar Pradesh has got 140 people there from his association.
58 as per.
So, my lord, may I
Not
say this?
factually incorrect,
More, my lord, I
No, my
want
lord,
to say.
of course there is something more.
58
My lord
minutes.
recognizes, my lord,
May I-
de-affiliated institutions, gets his people, my lord, and
Lord-
the original, my lord, associations are not there.
We are interested in the event.
Uttar Pradesh has.
It says no, but it has been stated nobody appears before High Court.
Let me extend the time for
That's what the union has said.
just a little bit, but 2-3 days, 4 days may extend it and then, or whatever.
Lord,
Let's
let
if I may submit.
But people
May I-
have already come, so.
of India certifies that the stadiums are playable.
My lords, in this,
The players, my lord, will have enough of, my lord, safety and security as far as this game is concerned. We have no objection.
By the way,
Yes, my lord.
by the way, this National Sports Federation, what is this RSFI?
roller skater.
Skating
Federation of India.
Okay, so this petition is by an intervener. Uttar Pradesh, this leave to file.
That's it. He's not.
Uttar Pradesh Roller Sports Association.
The reason.
So why you couldn't apply?
Melis, the reason being, because Melis, that is what I was trying to explain, Melis, because of this fight between the two factions. Now the president says the event will be in Tamil Nadu, Karnataka, etc. The secretary says that the event will be in Vizag, Vishakhapatnam. The High Court, Melis, till 29th of November doesn't decide on the venue. Suddenly, Melis, the High Court comes, decides the venue for itself without consulting the others. That is one, Melis.
High Court has stayed it.
Mr. Kamath,
Yes, my lord.
if Uttar Pradesh Roller Sports Association would not have come here,
That's it. You won't.
what would you have done?
Lord, I have challenged this order.
Where?
My lord, before the division bench, I have to say, my lord, I have
Okay.
challenged this yesterday's order, previous order that is pending. My lord,
So let the division bench decide it.
Lord, ultimately, my lord, lordships will have to take a call,
Where-
larger call, my lord. My lord, in light of
there is-
this.
Today, we have only two orders, an order appointing
That's-
commissioner
Yes, my lord.
and an interim order before, passed earlier.
Yes, my lord.
There is a subsequent order which has said as per schedule it will be held.
Yes, my lord.
Correctness of it, we should
Can't-
get it.
Melis,
No, that is passed
Melis,
yesterday, my lord.
These orders.
purely from the order, Melis, may indulge me for only 2 minutes, Melis.
Why are you all wasting time
Melis,
Not that.
of the court in such litigation?
Melis, there are two issues. I will
We
explain
have
to Melis
far
why.
more important matters to be
True.
decided.
2 minutes indulgence is all I seek, Melis. Purely to point out two issues, Melis. Purely to point out two issues, Melis.
Dismiss. Next
Just to
matter.
point out two issues, Melis.
Not
Just-
a single issue. Next matter.
Melis,
Pleasure.
the larger issue, Melis, may please permit me, Melis. I will be out of here, Melis, in 2 minutes, Melis. May bear with me. Last submission, Melis.
Challenge this order.
Melis,
Nobody has challenged this.
this order, because Melis, it came
I have
only on,
challenged this one.
Melis,
Where have you? It's not before us.
Yes,
Mr.
yes,
Kamath.
Melis,
We can't say anything on
You
that.
can join in the appeal filed by Mr. Khan.
Well, just one submission. Well, it is not related to whether the event will be held or not. Just one submission. The larger issue.
Participate next year.
That's all right, Melissa. That is where the issue is, Melissa. I'll tell how, Melissa. The national events decide as to who will be eligible to participate in the international events, Melissa. That is as per their rules.
Clash of egos.
18,
Nothing else.
18,
This litigation is nothing but clash
Government of
egos.
India can be asked
Oblige,
to
my lord.
Next,
come back with a report tomorrow that would solve the purpose, my lord.
pursue your appeal. Next matter.
So this is that circular on fraud and appeal. That's master circular on.
Mr. Banerjee, SG is not to come today. There's one another part-heard matter also at item 8.
Lord,
That fraud account.
Lord, sorry. Lord, I had only one request. I am for the Reserve Bank.
We are in the midst of one part-heard. Mr. Shakdar and Mr. Pava. Once it's over, then we'll call out this 8.
Grateful. I'm obliged. Grateful. Lord, I'll tell your lordship my difficulty. Lord, this is the 6th or 7th time. On the first day, your lordship, 1 minute. Your lordship,
No, Lord, I am not. I am Lord. He has asked me to start. I am just telling my learned friends that we are not. Yes, Lord, I am for the Reserve Bank. He's told me that if he's not there, I should start.
Once we are done with that morning part-heard, then we'll start hearing.
Lordship, grateful.
Sure.
Page 38. No, I want to show page 38. Second volume, man. Yes, I'm so sorry.
Yes.
Would my lords just oblige me by picking up volume 1 of my reply? Because an impression was given when the first investigation was carried out, it did not deal with the FUTP, Lord. Page 27, Lord, that at page, focus. At page, investigation.
First investigation report.
Yes, ma'am. That particular paragraph. Yes, my lord. Page 39, paragraph 2, my lord. I think my lords would have to add.
In volume 1?
Yes, my lord. Volume 1.
Page annexure?
Form, my lord, which is a part of the second report.
No, this is affidavit in reply.
No, my lord. Yeah.
A4, na?
A4, my lord.
Page
The affidavit in
158.
reply, annexure 4, which starts at page 38.
Additional direction. Yes.
Yes. Lord, in the middle of the page, they first give you the background of the case, not necessary. Your lordships have now broadly got to know what it is about. Because this was before the release of the escrow amount. But please see what's the focus of the investigation. The focus of investigation was to ascertain whether Kane had complied with the relevant provisions of 14.3, read with regulations so and so, that is the buyback regulation, that 50% if I don't reach, and there are exceptions, not exemptions. That's the wrong expression used. And FUTP regulations. My learned friend emphasized that this investigation was not about the last bit. And I am repeatedly, my lord, my concern has been, now please go to 7.
You read 38.
Yeah, 39, my lord. Printed page 39. In the middle, my lord, focus of investigation.
Yes, yes, yes.
My lord, the first paragraph. Scope of investigation was to ascertain whether Kane has complied with the relevant provisions of Regulation 14, bracket 3, with Regulation 15, capital B, 8 of the buyback regulations, and this is that PFUTP regulations, under which my lord, the show
That's
cause.
why they say at 8.20
Yes.
that PFTUP
Yes.
is being dealt with separately.
Yes, yes, my lord. The data, my lord, your lordship, I am being told to answer certain charges. The data you've got from merchant bankers who are registered with you, you got the merchant bankers to give you data from NSC. I asked for inspections when I got what he said is not his data, my lord. That 147, my lord, he said, this is not my data. I got it only in the DVD. Then in my reply to the show cause notice, which I read on 6/2/2019, I referred to those discrepant entries. Correct. So the least that I would have expected from the adjudicating authority was to say, sorry, the 4 entries that you're referring to do not form part of the data that I have. He doesn't say so. It was so simple to say, my lord, that the data that you're giving me is fudge. Now, please see what their legal department says, because this report also said, but see what the legal department says is 754, which is the second volume of my reply, my lord. 754. Does my lord have annexure 11, my lord? 754.
Yes.
All this I got out of, they were keeping serious charge, material not supplied to me only because of, I sort of stumbled upon this. Next year 11. It's draft note discussed with ED, SR, GM Santosh, etc. Investigation in the matter was conducted and draft investigation report was circulated to CIDC. VDA office dated 14th October 2015. As brought out in paragraphs 8.14 to 8.29 in the IR, Kane had failed to ensure that at least 50% of the amount earmarked for buyback is utilized in terms of Regulation 14 bracket 3 of the SEBI regulations. Also mentioned at paragraph 8.15 of the IR, 8.15 in terms of the regulation 15 capital B 8 of the buyback regulations. In the event of non-compliance with sub-regulation 3 of regulation 14, SEBI may direct merchant banker to forfeit escrow account subject to maximum of 2.5% of the amount earmarked for buyback, except in cases where these are the exceptions, and they found I fell within the exception. There's no exemption. My lord, also note that they keep saying exemption. There's no because they envisage a situation where you cannot buy 50%, which is the minimum. Volume weighted average market price, which was admittedly over 335 of the shares company during the buyback period, was higher than the buyback price as certified by merchant banker, based on inputs from judgments of this court, where your lordships have actually said that you violate these regulations that my learned friend is relying upon, are cases where you have Benami companies, Ponzi schemes, not for these kind of buyback which fall below 50%. And then you do a rear view wind driving and say, oh, well, you could have bought so many and so many days were favorable days. But please come to now, my lord, they give the 3 exceptions, and please turn the page and come to 755. Because penalty is not only on the company, 3 poor individuals who signed on the public document, my lord, public statement. Now, para 4, my lord.
Weighted average is one concept.
Yes, my lord.
The fact that it was higher than 335, around 341, 342, that is their case also. By this mechanism, you may meet it. of announcing a buyback, you created an expectation in the market which is very sensitive. Kept the, sale and purchase, demand and supply of an order, which maintained the price at a particular level. For that, he has to necessarily draw circumstantial evidence. He is referring to all this and he says PFTUP fraud is not the normal fraud as we understand in IPC or in even traditional civil. It is much broader. And he says inferentially, NSE, where your bulk of the trading takes place, shares you offer to buy, knowing that there are no selling forthcoming. BSE, where there is no trading, you are offering to buy. The figures from day one are of such huge extent that he says it's a divide. Pump up the price. That's his case.
Correct. But that
So,
case, he has to make,
on one side.
my lord, that case, there has to be a slightly higher threshold, because what he is saying is there is an element of intent in deceiving the exiting shareholder. Point number one. Point number two, when you show sell order of 1 crore, and I have given a mandate on a particular date to my merchant banker, say buy 2 lakh shares at a particular price range, which is say 319. I don't get equivalent matching orders. He doesn't have mandate to buy more. Now, SEBI can't tell me, no, you should have bought 1 crore shares. I assume their data is right. No, that's my answer. You need to get benchmark price. But see what they say in paragraph 4. This is their own department. Since this required interpretation of the provisions in the aforesaid regulations and examining the applicability of same in the instrumatter, the matter was referred to LAD. This is their legal department. VD Office of 3rd December 2015. In his notings dated 29 December.
Just tell me where you are reading.
Sorry, my lord, 755.
Yes.
Paragraph 4.
Yes. Since the required.
Yes. Since this required, does my lord just paragraph?
Yeah.
Since this required interpretation of the provisions in the aforesaid regulations and examining applicability of the same in the instant matter, the matter was referred to LAD. VD Office Note dated 3rd December 2015. In his notings dated 29 December 2015, ED has appointed as under. It appears, and this is the Legal Affairs Department, my lord. It appears that clause A of regulation 15B bracket A of the buyback regulations is attracted in this case. It is, if this is so, escrow forfeiture may not be applicable. This was when my 143 crores was being considered. Further, since the law itself provided the consequences of failure to achieve 50% level, it would be doubtful and legally difficult to sustain a case under FUTP regulations on the same set of facts and circumstances. And then they go on to the average price that your lordships put to me, as already mentioned in paragraph 8.19.
So what are those consequences of a failure to achieve 50% level?
My lord, if I don't, then it's forfeiture. But if I fall in the exemptions given in 15B, my lord, which is referred to in the previous page, which is if the volume weighted average price is more than 335.
What is 15 capital B bracket A?
Yeah, I'll show that.
Cap small a.
Yes, I'll show that, my lord.
Let us read that.
Immediately read that regulation. Now, this is a department, my lord, which refuses to accept 2 investigation reports of its own and the legal department's view. And says, Lord, Lordship, maybe an unwise decision. But that can't be that you are indulging in fraud and unfair trade practice.
There seems to be small a and small b.
Yes, my lord.
Right.
My lord.
And you need to fulfill both.
No, my lord. It is three situations, my lord. I don't have to fulfill both. That's my respectful submissions. But your lordships can also refer to the compilation that they gave. Is my lord having the regulation in front, my lord?
Yeah, it is in that compilation. Page 19 of the compilation, which again yesterday.
19.
19, my lords.
In the main file.
In the comparison we have yesterday, lordship.
Lord, yesterday
judgments and the regulations.
My learned friend gave a compilation
Yes,
of the regulations.
Yes.
So page 19 is relevant regulation.
197.
Page 19, my lords. 19.
19.
Part of the buyback regulations.
Yeah, it's part of the buyback. 15 capital B is what my
starts at page 3, I think, you know? they are stating.
In the event of non-compliance with sub-regulation 3 of regulation 14.
Yes, please first read 14.3, my lord, then it may make a little more sense. Chapter 4, at page 16.
Yes.
Does my lord have regulation?
Yes, yes.
A
The
company,
company shall ensure that at least 50% of the amount
in the open market, yes,
specified in resolution so and so is utilized
yes,
for buying back buyback shares.
from the open market through stock
Fine.
exchange, etc.
Now let us see 8.
Now, please come to 15B 8, page 20, my lord. Because they're dealing with forfeiture of escrow account. In the event of non-compliance with sub-regulation 3 of regulation 14, except in cases where Vishwanathan,
I got it.
yes, A, volume weighted average market price of the
We are not concerned with that. We are concerned with B.
No, my lord, A we are concerned with because this is what has been noted in the reports, my lord, that it was more than 335, the maximum value. These are the exceptions. Volume weighted average market price of the shares or other specified securities of the company during buyback period.
Inadequate sell orders despite buy orders. Here is case is inadequate buy orders despite such films.
So, my lord, A says that your average price is more than 335, which it was, and they don't dispute that position. Your escrow amount can't be forfeited. The legal department says, and that's why I showed my lord's 755, which said that if you cannot forfeit because he comes within the fray of the exception, and this is not an exemption, it's an exception, then the consequences of failure to reach 50% level, it would be doubtful and legally difficult to sustain a case under FUTP regulation on the same set of facts and circumstances. Correct, my lord? Now, despite this, my lord, this was of 3rd February. This legal opinion was of December of 2015. And please bear in mind that my period closed on 22nd July 2014. From January 14 to 22nd July 2014. And then I wrote to them, please give me back my escrow account. And they did 2 investigations, got a legal opinion. Thereafter, my lord, they released the amount only on 2nd February 2016. After they had verified the data from the merchant banker. My lord, one of the things that they could have done, I assume everything in my learned friend's favor. You should have issued notice to the merchant banker and said, I don't rely on your data. You got your data from NSE. You could have said that you've given me an input which is of doubtful character. They don't do anything. I had given a bank guarantee for 1,228 crores, my lord, to cover the risks. And that is also provided in the regulations. Would my lord just see this, my lord? I didn't point that out. Lord, in the very same regulations, please see what are the checks and balances. This is important, my lord. Chapter 2 of this very regulations, regulation 3, my lord. Please.
This is the para you showed. They said PFTUP may not be attractive.
Yes.
Legal department.
Yes.
This is the page you said.
Yes. 755, my lord.
That is part of which
Legal department's opinion.
part of which report?
My lord, that's the legal department which has given this opinion.
Legal report. That is beginning at 754.
Yes.
It is annexure to which report?
Annexure 11, my lord, that's they wanted a input from the legal department whether they can go ahead. It is a note which we found.
What is the date of this?
Lord, 20th January 2016 at the top.
And the third report is dated?
The third report, not there. Let me just give the report because it's in my list of dates. There is 11 June 2015. It's in my list of dates.
Yes.
My lord, serial number 9
Yes.
in my list of dates. 11 June 2015. Lord, SEBI didn't give you this date. Then serial number 10, 29 December 2015. SEBI again didn't give you this date. This is the document I was reading at 755, my lord. serial number 10. And the third, the other is, my lord, at serial number 12, 3/2/2016. Not referred to in their list of dates also. So, keeping back data, etc. Then, my lord, after this, now please turn the page of this list of dates. Serial number 13 is when they released after they had done 3 rounds. 2 reports, 1 legal opinion. 12/2/2016, they released my escrow of 143 crores. My lord, if after being satisfied. So if I was what they claim I was, why would they release 143 crores, allow a bank guarantee of 1228 crores to be released, which I had given in favor of the merchant banker, and then serial number 14 start again on 17th March 2017.
3 years after.
3 years after the event, more than 1 year, it's nearly 13 months after you release the escrow amount of 143 crores. My lord, it boggles me that you are imposing 5 crores whereas you could have actually imposed 143 crores. You may give any explanation now. Then I did an analysis. So one department is wanting to ensure that somehow I be held guilty of having committed a fraud on the exiting shareholders, committed an unfair trade practice. This is a very high threshold. You're dealing with a company which is multinational. If your lordships were to write today one word that what SAT did was not right, it will be a carnage vis-a-vis my shares. My lord, imagine the harm that an order of this kind could cause to the shareholders who have confidence in the company.
That way we can't pass any.
No, I am not saying that. I am only putting a
Think
perspective.
of the consequences in
No, my lord. My lord, let me moderate it. There, my submission is this, my lord. You have to, and I'll show those cases where your lordships have actually come down heavily on such companies. In fact, my lord, in another matter where the allegations were grosser, the court said there is not even a question of law which has arisen. You have to cross that threshold. I didn't even take that preliminary objection, my lord. But please see, how long can you wait? You issue me a notice on 17th March 2017. Now see what the adjudicating officer did, my lord, in his order. I was wanting to show my lords till. Please see volume 1, my lord. Civil appeal volume. My lord, annexure 1, A1, page 43. Please go immediately to page 48 or 47. Para 12, I'm not going to read it, my lord. I asked for inspections because I had given a preliminary reply on 19 January 2018. After that, I thought that the data that was being produced was not right. I asked for inspection. Page 48, my lord. Just above paragraph 14. My lord has that, my lord. It says, last 5 lines, the notices were also informed. My lord has that. Notices were also informed that investigation report with all annexures which were relied upon by SEBI for the purposes of issuing show cause notice are also open to the notice for inspection. Accordingly, the request of notices for cross-examination of officials of BSE and NSE were turned down, and hearing scheduled on 29th May 2018 was postponed till the completion of inspection of documents. I asked, because of my concern about the data, it is still my stand, my lord, that the 10th December 2014, where your lordships noticed that it's only the DVD, etc., they could have placed that DVD download on record or transcript on record. I got that in inspection along with the cover letter. Now, see, next page, my lord, page 49. Above paragraph 16, the last 2 lines, and what is that? Pursuant to carrying out inspection of documents, notices filed their reply dated 16th February 2019. Please note here, my lord, this is my second reply. Your lordship will find it in the list of dates also. My first reply was earlier, which was 19th January 2018. This is the reply which I read, and your lordship would see at page 378 of the reply volume. What did I say there? 378, my lord, my reply volume. He notes that, doesn't note what I have written there, and he deals with so many other submissions, but doesn't deal with something which was critical to me at least. I may have been completely wrong. He could have said that. But please see, volume 2, my lord, pages 378. It starts at page 78. Annexure 8. Does my lord have that? 6/2/2019. Right, my lord? Please turn to page 386, para 34, which I read, my lord. I'm just trying to connect the dots. I referred to these entries. Should not the adjudicating officer have dealt with it? He should have said, sorry, what you're telling us is wrong. वो दिखाओ मुझे वो मैंडेट लेटर्स 257.
Particular doubt, my brother.
Yes, ma'am.
Just 2 minutes.
Yes, ma'am.
Want to this also we ask for source of data page 597 599.
ये
597
नहीं 27 वाला बताना.
Days in the buyback period. So we are on page 12. My learned brother has raised a query.
Yes, my lord.
Total 123 days.
Yes, my lords.
Right?
Yes, my lords.
Out of 123 days, for how many days the price remained above 335?
Above 335. So, my lords, it would be minus 54.
54, it remained
Favorable. So, my lord, I'll just give the
69, 46 plus 23.
Yes. So that would be above the price.
It was 50%. And their own data will show, my lord, can I just complete this? Because your lordship would also know, lot has been said, my lord, that I gamed it. Please see page 288. Volume 1, page 288. Does my lord have that? Volume 1 of my reply, 288.
And during those 54 days, as per the finding, 67 crores shares were available.
That we have.
My lords have got. Lordships.
My lord, at what price is the crucial question, but I'll answer that also. Why 67 crores? My learned friend keeps repeating. It's very easy to say there were 60. If I didn't get a.
You hinted before lunch that you wanted to buy a 242 or 252.
I've given, yes. No. Lord, please see my mandates. Don't go by what I'm.
You said 252.
No.
What was your mandate to the
Lord,
bank?
322, I said, I think.
322.
Yes.
Maybe we heard it wrong.
No, maybe, my lord. Maybe I'm not saying your lordships. Lord, please see my mandates to the merchant bankers, which start at page 250. Volume 1. Now, my lord, the exchange opens at about 9:30 a.m. and goes on till 3:30 p.m. But please see at the top, the email says sent 12th March. Does my lord have that, my lord?
Page
250. 9:52 a.m. This is Morgan Stanley, my broker, my lord, my merchant banker rather. It's more order purchase of shares of Kane India Limited. Buyback. We place order to buy today's shares of Kane India at best market price as per the market rate as per below on NSE and BSE.
What was the closing price the previous day?
My lord, I can just look at that table and I can show it to you. But see, my lord, I did restrict it to one or the other. I said buy on either, but I did give the mandate saying 100% of volume traded for share at less than 380, 33% of the volume. And these are instructions, my lord. Your lordship will say total buy quantity be capped at 2 million shares. And then, my lord, the mandate said that this is valid till 3:30 p.m., my lord. Please look at 251. Okay, my lord, I have just confirmed the lowest price on this date, previous date. Lord, the lowest price I've just confirmed on this date, which I showed you, the previous date, was 326.
That is because
Yes.
you get it from the impugned order of the SAT.
Yes.
That it rose from 321 to 342. Probably at no point it came below 321, subject to correction.
I don't think so. I just verified.
We just saw in the paragraph which brother pointed out.
321.
Read it in.
317, 4th February, then 319.
It got. Because we saw some.
I'm giving the lowest. 319. 0.6, This is the historical data we've been because now, my lord, for example, I'm showing that data that is in the adjudicating
At page 14, perhaps on the top, my lords. Page 14.
ये वो जो दिखा रहे थे ना?
Page 12, 11.
Of the SAT order.
SAT order.
Just give me a moment. In fact, these were admitted facts. You know,
Yes, yes.
have read them and they didn't.
No, because you see the figure given here is
Yes.
January to July, BSC 321 to 343, NSC 321 to 343.
Correct, Lord.
So when did you read 317?
Lord, I took out a historical data.
From when?
Lord, this is right from the beginning. I'll tell my lords.
Date?
I'll give my lords. 23rd January 2014, which is 22nd July or 23rd July 20. That's the subject period.
Correct, but here it says 321 was the starting price. Just see. What the impugned order mentioned, you say the undisputed facts.
My lord, this I am instructed to say because they are calculating the increase. This is open and closed.
As on 23rd January.
As on 23rd January and closure
22nd July.
On 22nd July.
In between, it could have come down to 18 and 14.
And that is how I was giving mandate because I was executing orders, my lord. If you look at my emails and now see, my lord, now see.
Can't go it. See.
My lord, 257 onwards, your lordship would see.
When you say 321 to 343, that means it started with 321
and then it could have
ended at 343.
Not on the same day.
It could not have gone below 321.
No, on this can't be same day, Mr. Shagwar.
My lord, can I just read and let's just look because I have the data here. I have the data here. If your lordships want, I can just place it before my lord.
Could be also. So there's something called a circuit filter.
Yeah. It goes above
8%, I think. I don't know what is it.
Milos, can I just on this, or nothing on the merits, Milos? My friend said that we gave 4% premium than the market price to fix the cap at 335. If Honorable Court deducts 4% from 335, it comes to about 321, 322. My friend said,
I see. He's giving a premium of.
That's what is the argument. No. So I wanted to benefit the investors by agreeing at 335, which was 4% at premium. This was the submission.
So why mandate 318 yours?
Yes. So therefore, price ranged between this 320, 321 and upwards.
Can I? The problem here is that 335 is taken as the figure at which I have to buy. It is at or below. Therefore, from time to time, when I was giving a mandate, I was not only capping the volume. I'm sorry. I was capping. So
okay, do one thing. Vishal, Mr. Pava.
Yes, my lords.
Just formulate your submission.
Yes, ma'am.
Orally. 1, 2, 3. Then we'll request Mr. Shakhtar. Got it. Got the idea. Slowly.
Yes.
1, 2, 3. Yes.
The public announcement made by the respondent is an act of fraud. Considering the definition of fraud read with regulations 3 and 4 of PFUTP regulations. As per the law settled by this Honorable Court, in the matters covered by PFUTP regulations, inference of manipulations is sufficient to impute fraud. The definition of fraud under the regulations read with the regulations 3 and 4 are much wider than the fraud as is understood, even under the criminal jurisprudence. The adjudicating officer in the facts of the present case found that the public announcement made by the respondent was an act of fraud inasmuch as, despite having 54 available days out of 123 days on the stock exchange platforms to purchase 17 crore shares. Even though the available quantity of the shares was more than 67 crores. It's a clear act of manipulation of the securities market. The data utilized by the adjudicating officer is obtained from the NSE and the BSE. Covering all 123 days, including in particular details of each of the orders placed by the respondent, and also including each of the sell order quantity together with the price of the sell order quantities. These documents, including the data received from NSE and BSE, are supplied by the adjudicating officer to the respondent. The adjudicating officer also made available the entire record of investigation on different dates to the respondent.
This should suffice.
My lords.
Rest you can put it in your written.
My lords.
Mr. Shagdar?
Yes.
Just dictate in short.
According to the first respondent.
You need mic.
According to the first respondent, the data which was secured by SEBI was furnished by the merchant banker. The investigators of SEBI examined that, verified it, and certified it to be correct. Therefore, for SEBI to say that the data cannot be relied upon, which is part of the merchant bankers' input to them, in turn, based on the NSE and BSE data, is a valid data based on which inferences ought to have been drawn.
What does the data reveal?
Yes.
Dictate.
The data, according to us, reveals the buy orders were deflated and the sell orders were artificially enhanced by the adjudicating authority. Tara. The charge or the accusation leveled against respondent number 1 is that it indulged in fraudulent and unfair trade practices. Assuming without admitting, even if we were to accept the data used by the adjudicating authority, it would show that cumulatively, i.e. both on NSE and BSE, I had enough orders I gave enough orders to the merchant bankers to execute the trade.
Sufficient orders.
Sufficient orders.
Sufficient orders.
Sufficient orders. Third, the merchant bankers who are registered with SEBI and have to follow a code of conduct under the merchant bank regulations are bound to ensure that investors' interests are secured. SEBI, for whatever reason, chose, if it found that the data furnished by the merchant bankers was sullied for whatever reason, not to proceed against them. Para, 2 investigation reports, i.e. report dated 11 June 2015 and 3rd February 2016 recommended that PFUTP regulations were not violated. Next, as far as the legal department was concerned, it specifically went into the issue and concluded if the consequences for not achieving 50% of the maximum share purchase that respondent number 1, or we'll say buyback, that respondent number 1 had to achieve, then on the same set of facts, the case under FUTP regulations cannot sustain. Next, there is no question of law which arises for your Lordship's consideration under 15Z. Next, my Lord, sorry, can I?
Yeah, of course, of course.
I've given up this rule. Next, my Lord, I asked for cross-examination, which was declined. Whatever material is available today with the court is the material I received from SEBI only on inspection. Therefore, for SEBI to now say that what I have produced is, for the first time, is not the correct data, does not lie in its mouth. My Lord, the order of the Securities Appellate Tribunal, in our respectful submission, is the correct view, where after appreciating the evidence, it has come to a conclusion that the first respondent had not violated the FPUP regulations. The reasons, the facts which are contained, admitted facts, are provided in paragraph 11 of the impugned order. The reason has been provided by the appellate tribunal, the Securities Appellate Tribunal, in paragraphs 12 to, I'll give those paragraphs, 12 to 15 of the impugned order. The threshold for making good the accusation that I have violated regulations 3A to 3D and regulation 4 bracket 2 K and R, that is regulation, this will be FUTP regulation, and regulation 19.1
of buyback.
of 19 bracket 1, I think B also, of the buyback, 19.1 of the buyback regulations is not sustainable in the given facts and circumstances of the case.
Arguments concluded. Judgment reserved.
I appear to respond number 4. Because I have a slightly different submission.
Who are you?
I was the company secretary at the relevant point of time.
Huh.
I was, in terms of the SEBI regulation, I was mandated to have signed the public announcement because SEBI regulations require members of the board of directors and a company secretary / compliance officer to have signed the document.
Some action was taken against
This was also, I was also penalized. This was far above my pay grade. If I may just put it very simple.
So what is that penalty?
Because it was 15 lakh rupees was imposed as a penalty. Why we decided the monetary amount? Because it tarnishes the image. Because I today will function. I'm no longer with this group.
So what are your arguments?
So my submission is that adjudicating authority merely for the factum of me having signed the public announcement has held me guilty without examining my role in any manner whatsoever in this entire scheme.
Mr. Pava?
Yes, my lords.
What have you to say about
Yes,
this
my
matter?
lords, my friend's client, R4, was the compliance officer. She was just not the company secretary. My lords, in the public announcement, she would declare that everything is as per law. As per SEBI regulations, the compliance officers also can be held guilty, along with the directors on the board of the.
But Mr. Pava,
Yes, ma'am.
on the date when announcement was made,
Yes, madam.
and this company secretary signed the announcement, intention on the part of Mr. Shakdar also may not be other way around. It could be in the midway they may change their mind and they may decide, okay, ignore NSE, focus on BSE. Just because later something went wrong, would you hold him responsible because he has signed the announcement?
The submission to my lord says this.
We would like to know from you.
Yes, my lords. My lords, there's a regulation under the regulations.
How do you say?
Yes, my lords.
How do you impute to him
The inception.
at the inception itself
The conduct, my lords, as my lords may kindly.
was to defraud the investors?
My submission to the Honorable Court is this. The conduct from day one would depict the intent.
Except this, no other part played by him?
No, she had to make sure that
My lord,
Paragraphs of the impugnment.
I appear for 2 and 3 also, who are also individuals.
Who are they?
My lord, they are directors.
My lords, the compliance officer is the officer who not only makes a declaration when the announcement is made, he or she is also has to ensure that the entire buyback arrangement is executed, implemented as per buyback regulations. Entire process, she has to monitor, supervise.
Acha, this company
Compliance officer.
who has signed the announcement.
Yes, she's the compliance officer who has to comply.
So what steps she was expected to take?
My lords, the submission to my lord says this. The points of allegations which are directed against the
No,
director.
she had any further role to play?
The submission to my lord says.
She could have questioned the company that, well, you are not proceeding in line with the announcement. You are supposed to purchase it.
Yes.
Buy back it, huh?
The submission to my lord says this. Every public issue or a buyback arrangement dealing with securities of the market, the regulations provide for defining a compliance officer who is responsible to ensure that every part of decision, including the execution thereof, is implemented consonance with the SEBI regulations. And therefore, a specific appointment of an officer in the company is made pursuant to SEBI regulations. She was the compliance officer.
Okay.
That's the submission.
I wanted to rely upon.
File your written submissions. We'll look into it.
May I just draw your lordship's attention just to the one provision of the SEBI regulation? Because I did not, I mean, the public announcement was required to be signed by me in terms of SEBI regulation. I signed that. As I understood, my role was to really see the form, the manner, the content of the public announcement, etc. is fulfilled.
No. Mr. Pava travels a little further. He says, as a company secretary, you should have ensured that what has been announced is undertaken.
May I only submit? Perhaps the learned senior counsel travels beyond the adjudicating authorities or. because the adjudicating authority holds me liable ipso facto for the mere factum of having signed the public announcement. No, it doesn't say that I, as an individual, ought to have done X, Y, Z. I acted or omitted.
File your written submissions.
Please, sir.
Shagda?
And this judgment,
You said 2 and 3, who are they?
they were also directors. They were directors. They also simply signed.
The section 27 of SEBI Act, if you're promoted, section 20.
Put it on paper.
My lord, I just wanted to say this. There is one judgment, this is the latest judgment of 2023, my lord. Because my learned friend said these judgments say, Lord, the way the regulations are framed, whatever you may do, you will always be accused of fraud. In fact, there are so many papers that these regulations are flawed. But just see this judgment, my lord. One para 21. Mega, my lord. Where the allegations were gross. Lord, paragraph 2. I'm sorry, your lordships are perhaps tired at the end of the day. Just read paragraph 2, my lord. Mega corporation listed in Bombay Stock Exchange, etc. The attention of the share market regulator SEBI was drawn to an unusual price movement. Paragraph 2, my lord, your lordship could see. Of the scrip of the company between January 2005 to September 2005, company's shares traded between so and so. This upward spurt in increase in average monthly volume of shares to 1 crore 56 lakhs, etc. Having observed this activity, SEBI directed investigation while passing an ex parte order, etc. After hearing objections, interim orders were confirmed. Show cause notice was issued for the very same regulations, not 3A.
For you, we have gone through this judgment in some matter. For
Yes.
you, 23.1 and 23.2 are relevant.
Yes, my lord.
Read them out quickly.
Yes. The scope of appeal, my lord. The Supreme Court will...
Because SEBI is in appeal before us.
Yes.
Read it.
My lord, the Supreme Court will exercise jurisdiction, and here also will exercise jurisdiction only when there is question of law. And here also, my lord, SEBI was in appeal. Your lordship would have noticed that. The Supreme Court will exercise jurisdiction only when there is a question of law arising for consideration from decision of the tribunal. A question of law may arise when there is an erroneous construction of the legal provisions of the statute or general principles of law. In such cases, the Supreme Court, in exercise of its jurisdiction of Section 15Z, may substitute its decision on any question of law that it considers appropriate. However, not every interpretation of law would amount to a question of law warranting exercise of jurisdiction under Section 15Z. The tribunal, while exercising jurisdiction under 15T, apart from acting as appellate authority on fact, also interprets the Act, rules, and regulations made thereunder, systematically evolves a legal regime. These very principles are applied consistently for structural evolution of sectorial laws. This freedom to evolve and interpret laws must belong to the tribunal to subserve the regulatory regime for clarity and consistency.
That's all. That's all.
Correct, my lord? Now, issue number 2 deals with the same regulations which I am charged with.
Okay.
And the court came to the conclusion.
Arguments concluded, judgment reserved. Learned counsel appearing for the parties shall file their written submissions along with the case law they propose to rely upon within a period of 2 weeks from today. Thank you. Thank
Please,
you.
Lord. Grateful to you, Lord.
Deeply obliged.
Best of luck.
Deeply obliged. Can I give you?
Mega.
This, your lordships have directed us to file written submissions plus. I think all parties have. I'm just putting it's on record.
The short point.
Short point because we have filed a detailed written submission. All sides have filed.
Yes, Mr. Doe.
Lord, I am appearing for the Reserve Bank. Although I am a respondent, my Lord, I am supporting the petition. My Lord, 2 questions, my Lord, which your lordships had framed. My Lord, first is whether Rajesh Agarwal, my Lord, mandates that a personal hearing should be given. My Lord, my submission, my Lord, is that Rajesh Agarwal does not mandate personal hearing, and I'll, my Lord, indicate why. My Lord, Rajesh Agarwal was a case under the 2016 master directions. If your lordships kindly see the 2016 master direction, because we are now today, my Lord, considering the 2024 master direction. There is, my Lord, a sea change. Kindly see the 2016 master direction. My Lord, those directions your lordships will find are, my Lord, at page 26 of the SLP paper. And kindly see, my Lord, page 30 2.1.3. At page 30. May I read?
Yes.
Banks, with the approval of their respective boards, shall frame internal policy for fraud risk management and fraud investigation functions based on the governance standards relating to the ownership of the function and the accountability resting on defined and dedicated organizational setup and operating processes. So, my lord, all that the 2016 guidelines did was to leave it to the banks to formulate their own internal policy. And thereafter, my lord, the Reserve Bank did not give any directions on what that policy should be, what it should, my lord, encompass. So it was, my lord, a blanket, my lord, in that sense, a carte blanche which was given to banks, that for the purposes of, my lord, fraud risk management and fraud investigation, we leave it to the wisdom of the bank concerned on what, my lord, its own internal mechanism should be. That is what fell for, my lord, consideration in Rajesh Agarwal. And because, my lord, there was absolutely no, my lord, requirement of audi alterum partem, your lordships have therefore, and I'll come to Rajesh Agarwal in a minute, your lordships therefore interpreted the need for, my lord, a hearing. And in our respectful submission, my lord, the hearing that Rajesh Agarwal discussed, contemplated and directed was a hearing and not a personal hearing. And I hope to, my lord, make that good when I, my lord, would request your lordships to revisit Rajesh Agarwal in the way in which...
So, hearing would not include personal
No.
hearing. That's your
Oral. Yes, my lord.
So, what type of hearing?
My lord, I'll tell you, lord. My lord, would your lordships therefore straight away turn to the 2024 master directions? Because, my lord, having, my lord, seen your lordship's decision in Rajesh Agarwal, the master directions have been amended in light of, my lord, what the RBI has observed, and specifically to incorporate, my lord, the mandate of this court in Rajesh Agarwal. Your lordships will find that, my lord, the 2024 master directions have been, my lord, placed on record in an application to place additional documents on record. Kindly see, my lord, page 21 of, my lord, that application. Annexure A3. IA 2322997. May I read, my lord? 15th July 2024. Do your lordships have page 19, my lord?
Yes.
Please find enclosed annexure RBI fraud risk management so and so directions 2024 issued in the exercise of powers so and so. These directions shall supersede the earlier directions on the subject, namely, my lord, the RBI directions of 2016. So the current legal regime is, my lord, the 2024 directions. And if I can request your lordships to, my lord, kindly see just two paragraphs of these directions, my lord, which are at page 22.
These are 2024.
These are 2024. These were not challenged before the High Court. The vires of this, my lord, was not an issue before.
So, in what manner they differ with 2016?
Yes. I'm grateful, my lord. Please see page 22, chapter 2. Do your lordships have it, my lord?
Yes, chapter 2.
My lord, please see governance structure in banks for fraud risk management. Your lordships had seen complete freedom given to the banks to formulate their own policy. Now, my lord, please see what the new regulations say. 2.1.1. There shall be a board approved policy on fraud risk management. Now, please note, my lord, delineating the roles and responsibilities of the board, board committees, and senior management of the bank. The policy shall also incorporate. Now, my lord, this is what I'm highlighting. The policy shall also incorporate measures for ensuring compliance with principles of natural justice in a time-bound manner, which at a minimum shall include, and please see, my lord, where natural justice is to be found, your lordships will find footnote 5, and footnote 5, my lord, specifically says that, my lord, it is inspired by your lordship's decision in Rajesh Agarwal. So
it is a circular reinforcing the judgment in Rajesh.
yes, my lord.
Then why do you say
Because,
that
my lord-
Agarwal doesn't apply?
Yes, so my lord, no, my lord, I am saying Rajesh Agarwal does not mandate a personal hearing. That is the understanding, my lord, of the Reserve Bank of India. Therefore, this circular provides for all other, my lord, safeguards of audi alteram partem, and I'll indicate what they are. But stop, sir.
Mr. Dhoni, the understanding as per footnote 5 is
Yes, my lord.
Rajesh Agarwal only speaks of representation.
Yes, my lord.
You are right if the word used was a representation.
Yes, my lord.
But as any case law in administrative law, construed hearing not to include a personal hearing.
Yes, my lord. There are a series of decisions, but my lord, let me just answer your lordship's question of what are the safeguards which have now been introduced. I'll come to, my lord, the point of hearing. Now, please see, my lord, what these at a minimum shall include. 1. 2.1.1 issuance of a detailed show cause notice to the persons, entities, and promoters, whole-time and executive directors against whom the allegation of fraud is being examined. Now, please see, my lord, the show cause notice shall provide complete details of transactions, actions, events, basis which a declaration and reporting of a fraud is being contemplated under these directions. So, my lord, it has to be particularized. This is, my lord, the mandate of the circular. We are no longer leaving it to a bank to decide what the show cause notice must say. There has to be a granularity of, my lord, detail in the show cause notice. Then please see 2.1.
RBI never came to this court seeking a clarification of Rajesh Agarwal.
it didn't.
Why?
My lord, this is the understanding.
If this was your understanding, you should have, on the very next day, you should have come forward that please clarify.
Lord,
where do you read personal hearing?
yes. So, my lord, but can I just finish this entire 2.1? My lord, the reason why, my lord, no clarification was sought for is because, my lord, the banks had sought a clarification and your lordships had already clarified. I'll come to that in a minute. But, my lord, can I just complete the other, my lord, procedural safeguards? A reasonable time of not less than 21 days shall be provided to the persons or entities on whom the show cause notice was served to respond to the show cause notice. Then 2.1.1.3, banks shall have a well laid out system for issuance of show cause notice and the examinations of responses and submissions made by persons or entities prior to declaring such persons or entities as fraudulent. And, my lord, 1.2.1.1.4, a reasoned order shall be served on the persons to entities conveying the decision of the bank regarding declaration or classification of the account as fraud or otherwise. Such orders must contain relevant facts, circumstances relied upon, submissions made against the show cause notice, and the reasons for classification of as fraud or otherwise. So, my lord, now the regulatory scheme which has been put in place is, at a minimum, you will give a detailed, particularized show cause notice. You will consider, my lord, the representation which is received, and you will pass a reasoned order which will, my lord, which must contain the facts and circumstances on which the bank relies upon, the submissions which have been made against those, and, my lord, the reasons why, my lord, the authority considers it, my lord, either acceptable or not. Now, this entire, my lord, process of show cause, reply, and adjudication was not there in, my lord, the 2016 master directions, and that is how, my lord, Rajesh Agarwal fell for consideration. Now, all these have been incorporated. The petitioners are saying this is not enough. You must additionally import a requirement for a personal hearing. And, my lord, I hope to persuade your lordships that Rajesh Agarwal, your lordships, did not mandate, my lord, the need for a personal hearing.
Let us test this argument.
Yes.
To enable us to understand.
Yes.
Come to page 112.
Yes. Yes.
Come to, let us read from para 98.1.
Yes. My lord, may I read? My lord?
Yes, yes, of course.
The conclusions are summarized below. No opportunity of being heard is required before an FIR is lodged and registered.
Undoubtedly.
Yes.
Undoubtedly.
Yes. Classification of an account as fraud not only results in the reporting of the crime to the investigating agencies, but also has other penal and civil consequences against the borrower. debarring borrowers from accessing institutional finance under clause 8.12.1 of the master directions on frauds results in serious civil consequences.
This would remain in your
Yes,
2024 also.
consequences will remain.
Right. Now 98.
Such a debarment under clause 8.12.1 of the master directions on fraud is akin to blacklisting the borrowers for being untrustworthy and unworthy of credit by banks.
Correct.
The court, this court, now Mullah, this is very important. This court has consistently held that an opportunity of a hearing, and this is Mullah, where I, my lord, commend for your lordship's consideration, that the judgments which have consistently held, including the judgments noted in Rajesh Agarwal, do not use the word personal hearing. They are all judgments in the context of a hearing. That is, you will hear what somebody has to say, not give that person an opportunity to come before you and orally argue.
So how will that person hear?
Yes. So, my lord,
by reading his reply.
Yes. So, my lord, therefore, my lord, since this word hearing, when I take your lordships from Rajesh Agarwal from para 1, your lordships will be no doubt that, my lord, hearing does not mean oral hearing or personal hearing.
Okay.
Yes. So, my lord, if I
Proceed.
can just read, my lord, the balance part.
Proceed further.
Yes. Opportunity of hearing ought to be provided before a person is blacklisted. The application of audi alteram partem.
Keep one thing in mind. We are with you. When you say no adjudication, there need not be any adjudication, but at least minimum some hearing before the authorities is also to be ruled out.
So, my lord, my lord.
See, your argument comes to this. We issue a show cause notice.
Yes.
You have to file your reply.
Yes.
Whatever you say, we will look into and we'll take a final call.
Yes.
Fine. That exercise does not involve any adjudication. Now, a step further. Someone comes to you.
Yes.
Maybe a lawyer, a chartered accountant, or the party himself in person. He would say, I have received this show cause notice. This is what I have to say.
Yes.
Even at that point of time, you are not undertaking any adjudication. You are giving him an opportunity of hearing.
Yes.
You are ruling out that also.
No. So, my lord, let me, my lord, place what the position is. My lord.
You didn't answer our question.
Yes, I'm answering your lordship's question, my lord. My lord, I would respectfully submit that when a bank takes a decision on a show cause notice, it is effectively exercising an adjudicatory function. Because, my lord, you are ultimately deciding the merits of an allegation of, say, diversion of, my lord, funds, etc. So there is an element of adjudication. It is not akin to an adjudication by a civil court, but it is certainly, my lord, a determination of the merits of the allegations in the show cause notice. So I am not, my lord, I am not even saying there is no adjudication. Yes, there is an assessment and a decision that the authority has to take by passing a reasoned order on, my lord, the allegations which have been made in the show cause notice. So I don't for a minute say, my lord, there is no adjudication. Yes, there is an element of adjudication. The only, my lord, departure which I have, my lord, is I am respectfully submitting that process need not involve giving somebody an opportunity of a personal or an oral hearing. And I hope to, my lord, persuade your lordship that neither did Rajesh Agarwal say so when I, my lord, point out some paragraphs of Rajesh Agarwal to your lordships. Because Rajesh Agarwal was considering a situation where...
Why Rajesh Agarwal had to prefer a petition in the Telangana High Court?
Yes. So, my lord, may I? My lord, Rajesh Agarwal is 20. Sorry.
Was he issued a show cause notice?
No.
He was not issued a show cause.
My lord, 2016 regulation.
No. In Rajesh Agarwal, show cause notice was not issued.
My lord, Rajesh Agarwal is a case where there was no show cause notice. My lord, the objection in Rajesh Agarwal was one fine day you come to know from outside that you have been declared to be a fraud. That is the allegation. And when I show your lordships paragraph 1 of Rajesh Agarwal, that will be so...
Just let us read 1 and 2.
Yes.
In the civil appeals
Yes.
arise of page 80,
Yes.
annexure P4.
Yes. My lord, would your lordship see para 1 of Rajesh Agarwal?
That's what I'm saying.
Yes, yes.
1
Now,
and 2.
yes. Now, my lord, please see this civil appeal arises out of a challenge to the RBI fraud circular of 2016 issued by the RBI. These directions were challenged. So, my lord, the fraud circular itself, these directions, which are called, my lord, the master directions, were challenged before the High Courts primarily on the ground. Now, please note, my lord, no opportunity of being heard is envisaged to borrowers before classifying their accounts as fraudulent. Now, my lord, what is this opportunity of being heard that 2016 was under challenge? That you have left it to banks. Banks do not give a show cause. Banks do not invite a response. Banks pass an order with, my lord, no my lord, semblance of natural justice. Banks do not communicate that order to us. One fine day, we discover when our name comes on, my lord, on some website which is, my lord, for notifying people who are frauds. That is where we come to know that I have been declared to be, my lord, a fraud account. So the hearing that is contemplated, my lord, is, my lord, that I am completely kept in the dark. That is the Rajesh Agarwal challenge, because Rajesh Agarwal in 15 places cites judgments which have said oral hearing or personal hearing is not necessary. It is not a requirement of, my lord, audi alteram partem. I'll show that. Now, please see, my lord, a little later, my lord. The High Court of Telangana has held that the impugned judgment that the principles of natural justice must be read into the provisions of the master directions on fraud. The decision has been assailed by RBI and lender banks through these civil appeals. Now, please see, my lord, the second paragraph. In this background, this court has to consider whether the principles of natural justice should be read into the provisions of the master directions on fraud. For the reasons to follow, we hold that the principles of natural justice, particularly the rule of audi alteram partem, has to necessarily be read into the master directions on fraud to save it from the vice of arbitrariness, since the classification of an account as fraud entails serious civil consequences for the borrower. The directions must be construed reasonably by reading into them a requirement of observing the principles of natural justice. Now, there, my lord, there was a complete exclusion of any form of natural justice.
Understood.
2024, it is there.
Clear.
Now, my lord, please see paragraph 5. On 15th of February 2019, JLF declared the account of the company as fraud by invoking clause 2.2.1g of the master directions on fraud. Subsequently, the Fraud Identification Committee passed a resolution on the 31st of July identifying the company's account as fraud. Company filed a writ petition before the challenging both the decisions of the Joint Lender Forum and the resolution of the FIC dated 31st of July 2019 before the High Court of Telangana. So, my lord, that was a case of complete exclusion. The court said if there is complete exclusion, we will read it into it. And what the court has read into it, my lord, in our respectful submission is, yes, you must give a hearing, but that is not a personal hearing. And that is why, my lord, our understanding of that judgment, we have modified our regulations to, my lord, provide for this. Now, my lord, would your lordships now kindly see, my lord, the second SLP, my lord, which was before the court, my lord.
You
which
also need to assist us.
Yes.
It's a debatable issue.
Yes.
We'll ask SG also
Yes.
to assist us. This entire judgment of Rajesh Agarwal is based on the fine principles enunciated in Binapani,
yes,
the landmark,
yes,
Menka Gandhi,
yes,
Mohinder Singh Gill,
yes,
Canara Bank.
Yes.
In all these decisions,
yes,
two things emerge.
Yes.
If the consequences are bad, civil consequences are severe, you need to give hearing.
Yes.
Your argument today is audi alteram partem in all cases would not include opportunity of personal hearing. So you just assist us on this proposition which you want to carry.
Yes. So, my lord,
three things are clear.
Yes.
Rajesh Agarwal, there was no show cause notice.
Yes.
He had no opportunity to file a reply. He comes to the High Court, challenges the circular. Circular is looked into. Telangana High Court says no.
Yes.
You must incorporate a provision, a clause, to provide an opportunity of hearing.
Yes.
Ultimately, matter travels to the Supreme Court.
Yes.
Supreme Court, relying on all these judgments, said that if the civil consequences, every order or proceeding which involves civil consequences or adversely affects a citizen should be in accordance with the principles of natural justice.
Yes.
You are, for the time being, excluding the personal hearing part from the principles of. In what circumstances you can do it, you just assist.
Yes.
Only one interjection, if you
Yes.
Before laying down this proposition in Rajesh Agarwal in para 81, apart from the judgment your lordships my lord, immediately pointed out, before some time pointed out, there are two judgments also which are cited, that is Swadeshi Cotton Mills and second is of Tulsiram Patel, which takes the view that calling for an explanation is also a sufficient compliance with principle.
Will it not depend on facts of each case?
These two are also.
So both of you should make us understand why you don't want why this personal hearing should go. That's all.
Yes. So, my lord, may I endeavor to answer your lordship's first question with reference to Rajesh Agarwal itself, so that, my lord, kindly turn to paragraph 15 of Rajesh Agarwal at, my lord, internal page 19.
Yes.
15.1. Under clause 8.9.4 and 8.9.5 of the master directions on fraud. Now, please note, my lord, this is what was troubling the court. No notice.
We are absolutely clear now.
Yes.
You can proceed further.
Very well. Yes.
Now, your endeavor should be to make good your submission.
Yes.
That in the present case,
yes,
in cases where bank has to declare an account to be a fraud account,
yes,
hearing means issue a show cause notice, call for the reply, look into it, take an appropriate decision.
Yes.
Either it is declared or the notice is discharged.
Yes.
But there is no question of giving any personal.
Yes. Now,
that's all.
Yes. Now, my lord, please note paragraph 15.8. I'm just showing your lordships now the approach that your lordship's court has taken. Please see para 15.8.
Yes.
The decision of this court in SBI versus Jha Developers. Jha Developers, my lord, was a willful defaulter case. So, a case, my lord, fairly, my lord, RBI circular for willful default. The decision and the consequences are the same, that, my lord, you are barred from obtaining institutional finance.
Fine.
My lord, may I request your lordships to kindly see paragraph 15.8.
8.
Yes, 15.8, my lord. So, Rajesh Agarwal notes Jha Developers. That's what I'm pointing out. Please see, my lord, the decision of this court in State Bank of India versus Jha Developers. Please note, my lord, read in the requirement of natural justice for the purposes of declaring a borrower as a willful defaulter. The principles laid down in Jha Developers would be squarely applicable to the present matter. This is the submission. It's not, my lord, your lordship's finding. I'm only pointing out. So, Jha Developers was relied upon by the petitioners to say, in Jha Developers, the Supreme Court has read in, my lord, the principles of natural justice. But the Supreme Court has, my lord, said while reading that in, and I'll come to Jha Developers, that does not include a personal hearing. Now, my lord, if your lordships kindly see, and it is a RBI circular for, my lord, willful defaulters. The consequences are the same. And still, my lord, your lordship's court said no personal hearing we will not read in. The other requirements of audi alterum partem, notice, submissions, etc., consideration, speaking order, my lord, will have to be provided. Now, my lord, would your lordships kindly see, my lord, from paragraph 17 onwards.
No, we want you to read 15.9 also.
Yes, I'll read 15.9, my lord. My lord, 15.9.
What is the court trying to convey?
Yes, my lord, the part, sorry, this is, my lord, the submission, but I'll read.
No.
Yes, my lord, if your lordships kindly see.
They are submissions?
Yes. These are
submissions.
These are submissions. That's why, my lord, when I read.
So the account holder conceded that in so far as preparation of forensic audit report, etc. is concerned, there's no question of applying this dictum.
Yes.
All right?
Yes.
Okay.
Now, my lord, yes. Now, the contrary submissions your lordships will find in paragraph 16. I will, my lord, not read them because, my lord, your lordships may come straight to the analysis from para 17 onwards, which is, my lord, where the regulatory framework is considered. I'll, my lord, skip the entire regulatory framework because, my lord, this was the framework of the 2016 directions. And, my lord, we come straight to, my lord, where audi alteram partem is discussed in paragraph 36 onwards. So this is, my lord, the core discussion on how much should be imported, what is, my lord, a necessary concomitant, is personal hearing a necessary concomitant. We need to bear in mind that the principles of natural justice are not mere legal formalities. They constitute substantive obligations that need to be followed by a decision-making and adjudicating authorities. The principles of natural justice act as a guarantee against arbitrary action, both in terms of procedure and substance, by judicial, quasi-judicial, and administrative authorities. Two fundamental principles of natural justice are entrenched in Indian jurisprudence: nemo judex in quasi sua, which means that no person should be a judge in their own cause, and the second one, my lord, audi alteram partem, which means that a person affected by administrative, judicial, or quasi-judicial action must be heard before a decision is taken. The courts generally favor an interpretation of a statutory provision consistent with the principles of natural justice, because it is presumed that statutory authorities do not intend to contravene fundamental rights. An application of the said principle depends on the facts and circumstances of the case, express language, and the basic scheme of the statute under which the administrative power is exercised, the nature and purpose for which the power is conferred, and the final effect of the exercise of that power. While the borrowers argue that the action of the banks in classifying borrower accounts as fraud, according to the procedure laid down under the master directions on fraud, is in violation of the principles of natural justice, RBI and lender banks argue that now please note, these principles cannot be applied at the stage of reporting a criminal offense to investigating agencies. At the outset, we clarify that principles of natural justice are not applicable at the stage of reporting a criminal offense, which is a consistent position of law adopted by the court. So as your lordships told me, my lord, your lordships are not, my lord, going into that. So, my lord, then they cite Vin Chadda, and para 39 is, my lord, as far as reporting of criminal offense is concerned, no requirement of, my lord, audi alteram partem. Now we come to, my lord, as far as, my lord, the non-criminal part is concerned in paragraph 40. And this is where, my lord, your lordships will find, after paras 1 and 2, again, my lord, the seeds of the expression opportunity of being heard is, my lord, comes in. Now, please see, my lord, para 40. The process of forming an informed opinion under the master directions on frauds is administrative in nature. This has also been acceded to by RBI and lender banks in their written submissions. It is now a settled principle of law that the rule of audi alteram partem applies to administrative actions apart from judicial and quasi-judicial functions. It is also a settled position in administrative law that it is mandatory to provide, and then, my lord, the words, for an opportunity of being heard. And this is, my lord, where I hope to persuade your lordships that opportunity of being heard is not, my lord, to be taken to mean an opportunity of being provided a personal hearing. An opportunity of being heard when an administrative law action results in civil consequences to a person or entity. Now, my lord, in support of this is the heart, my lord, whether an opportunity of being heard as contemplated or as discussed in Rajesh Agarwal was, my lord, an opportunity of a oral or a personal hearing. Now, the first decision which is quoted, my lord, in para 41 is, my lord, Binapani Devi, this is not a case of a personal hearing. This is a case, my lord, where the argument was you must consider what the person has to say. So I am, my lord, pointing out that every single decision, including Jaha developers, which your lordships used in support of the proposition, is a judgment for, my lord, the proposition of a hearing and not, my lord, a personal hearing. So, my lord, State of Orissa versus Binapani Devi is, my lord, not a personal hearing case. Now, please see, my lord, in State of Orissa versus Binapani Devi, a two-judge bench of this court held that every authority which has the power to take punitive or damaging action has a duty to give a reasonable opportunity of being heard. The court further held that an administrative action which involves civil consequences must be made consistent with the rules of natural justice. And then, my lord, they quote paragraph 9, the rule that a party to whose prejudice an order is intended to be passed is entitled to a hearing applies alike to judicial tribunals and bodies of persons vested with authority to adjudicate upon matters involving civil consequences. It is one of the fundamental rules of our constitutional setup that every citizen is protected against exercise of arbitrary authority by the state or its officers. Duty to act judicially would therefore arise from the very nature of the function intended to be performed. It need not be shown to be superadded. If there is a power to decide and determine to the prejudice of a person, the duty to act judicially is implicit in the exercise of such power. If the essentials of justice be ignored and an order to the prejudice of a person is made, the order is a nullity. This is a basic concept of the rule of law, and importance thereof transcends the significance of a decision in a particular case. Then, my lord, second is, my lord, I'll, my lord, invite your lordship's attention to Binapani Devi separately, because I don't want to, my lord, keep moving from this judgment to the other cases. But, my lord, second, my lord, which is relied upon is, my lord, Maneka Gandhi. I don't want to, my lord, take Maneka Gandhi in this before your lordships. So, my lord, 41, 42, the decisions which are cited in aid of paragraph 40 are not cases which mandate that there has to be an oral hearing as a necessary concomitant of a hearing contemplated in light of, my lord, principles of natural law.
You're trying to say that English translation of audi alterum partem, condemned unheard, has been adapted as hearing.
Yes, my lord, condemned unheard will mean that you don't even hear what the man has to say. By hear, my lord, means you are not even cognizant, or you don't even give that person an opportunity of putting forth his or her point of
Hearing
view.
has to be understood to mean can't be condemned unheard.
Correct. Yes, my lord.
But as you go down, because you will show the clarification order, there is a place where they say reply and represent.
Yes, so my lord,
go in your own way.
Yes, so my lord, now, my lord, I'll come to Binapani Devi in a little while. Then, my lord, paragraph 43 onwards, they deal with the argument that a classification as a fraud does not have civil consequences, and your lordships have said no, it has civil consequences. So, my lord, 43 onwards, the inquiry of, my lord, whether there are civil consequences or not, my lord, is considered. That door is shut, that yes, it has civil consequences, and nobody can say that there are no civil consequences. Now, please see para 52, where, my lord, the court comes back to Jha. The question in Jha developers was whether a person who is declared to be a willful defaulter, according to the procedure laid down in the Master Circular on Willful Defaulters, is entitled to be represented by a lawyer of their choice before such a declaration is made. The court held that a borrower does not have the right to be represented by a lawyer in the course of the in-house proceedings envisaged in para 3 of the Master Circular of Willful Defaulters. Para 3 of the Master Circular on Willful Defaulters provides a two-tier process or identification. At the first stage, my lord, there is a first committee headed by an executive director. Then, my lord, there is the first committee's recommendations. Then, my lord, there is the second stage, which is, my lord, discussed in Placitum C. And then, my lord, please see what it says. Thus, it is clear that the procedure for a declaration of a borrower as a willful defaulter is different from the procedure envisaged under the master directions of fraud for classifying a borrower's account as fraud by virtue of clause 8.12.1 of the Master Directions on Frauds. Penal consequences applicable to a willful defaulter also apply to fraudulent borrowers. Thus, although the procedure adopted for a declaration of a willful defaulter is different from that envisaged for classifying the borrower's account as fraud, they will face similar consequences. So, my lord, if for willful defaulter there is, my lord, civil consequences, the same civil consequences, my lord, will flow as far as the fraud master directions are concerned. And the court, my lord, therefore says that civil consequences ensue is something which the court answers, my lord, against the Reserve Bank and the banks. Now, my lord, please see 53. Since the consequences flowing from the two, my lord, would your lordships want me to stop here?
Yes, because we have to attend one another matter.
My apologies, my lord. At 2 o'clock, I could not be here, but I had a meeting at 2 during lunch hours. Mr. Banerjee was also there. Officers were also there. My apologies, my lord. I was on my legs. I know, my lord, but I owe an apology.
Monday.
Monday.
Once we are done with the admissions, we'll start.
That's
much. That's
much.
Can it be at 2 o'clock, my lord? So, I think before 2, your lordship should not be free.
It will be 2 o'clock.
Go, please.
Priya is there. Sanil is there.
Both the parties have joined online.
Yes, yes.
Yes, my lord.
Supriya, can you hear us?
Yes, I can hear.
Are you able to hear us?
Yes, I'm able to hear you. Am I audible?
Yeah, you are audible. Last time you were unable to join.
Yes, I'm so sorry. There was some connection
all right.
issue,
But,
connectivity issue.
We were quite happy with what has transpired over a period of time after our last meeting.
Mm-hmm.
So, would you like to share something with us?
Sure, definitely. Visitation wise, yes, the child was okay, but at the same time, there were some logistical concerns and hiccups in terms of, I mean, I feel it can be bettered by just understanding the child's schedule, because she had her school, and the one that full week went by where she had school and we were returning late. I feel this can be taken care of. Then, in terms of our discussion with respect to resolution and how to go about, we had some intense. Hello?
That is important.
Yes.
Yes.
In terms of, I mean, with respect to our problems, and it was intense, unpleasant. I would like to say the fundamental problems remain the same. I felt like my concerns were not being taken into consideration. We were not able to get to a solution. Like the fundamental issue remains the same. Like how do we prevent this from happening again? How do we come to a resolution that, we're not having the same issues? So that was the crux of how the conversation went between the two of us. Then with my parents, similarly, it went in a similar fashion. I think they would be able to talk about it best. My dad is online. My mom can also join in to, maybe they can directly tell you how their conversation went. But otherwise, if he's, I'm absolutely okay with visitation and taking this forward. I have no qualms whatsoever in that. I'm only happy to facilitate. Hello?
Sanil? Sanil?
Not there?
Sanil, are you there? Sanil? Have you joined?
He has joined, Your Lordship.
Yes, he is there.
Ah.
Am I audible?
Yes, you are audible.
Sir, as Supriya mentioned,
You heard what Supriya had to say?
Yes, sir. As she mentioned, we had a good discussion. I had a discussion with her as well as with her parents. I tried to address all her outstanding concerns as best as possible. I have not heard from her what it would take for her to return yet, and I've been asking these questions through my counselor. I've posed this question directly to her parents. I've asked this question to her as well.
Okay.
If there are concerns, I'm willing to work on that. As I said, 3 years ago, the situation was not ideal. I was just coming out of a layoff. Things are much better at this stage of my life.
Just a minute. Just a minute. Okay.
So if I may request, I mean, a one-on-one so that I can give a little more, to talk to you all one-on-one, I would be able to get into the nitty-gritty. If that is possible at any point, I mean, in January or whenever I could.
Okay, done.
I would really
Now
appreciate it.
see, Supriya, Sanil.
Yes, sir.
Is Ananya there? No.
Yes, she's around.
She's there.
Yes.
Where is she?
She's just getting. She's in the other room.
Lord, if you could also speak to her parents for a minute.
Okay.
Be great.
Hi, Ananya.
Hi.
How are you?
I'm fine.
If you would have come to the Supreme Court, we would have offered you a pizza. Last time you relished it. Fine, next time. Okay.
Next time.
Okay. You go. Enjoy.
Thank you.
Okay. Now our suggestion to both Sanil and Supriya, please keep talking, keep talking, right? We'll keep this matter sometime in January 2026, in the new year. And you can personally come down, Supriya.
Okay.
To Delhi.
Okay.
Sanil, if it is convenient to him, if he gets leave, and if he is able to come down, nothing like that.
My lords,
we have suggested to Sanil that Christmas is now approaching. He may think of coming to Bombay, spend some time with you all. And in the second week of January,
Can stay back for first week. We can have it on 5th itself.
if you, Sanil,
Your Lordship is.
So can I add something, sir?
Go to 4th January.
You're opening on 5th.
Sanil,
We can ask him to stay back.
if you can come down, down in the last week of December and stay back up to 5th. We'll keep this matter on 5th itself. That will be the first day after our winter vacation. Okay?
Sir, thank you very much, sir. I'll be happy to stay back and I'll be there in person on 5th, sir. Sir, I just have a request. Sir.
Yes.
Sir, I'm planning to come down during the Christmas vacation.
Very good.
Sometime between 25th and 6th. The dates are yet to be finalized.
Very good.
I understand that this is the time of vacation for our daughter. So my humble request is during this time, I should be allowed to meet my child during the day, spend time during the day, later in the evening, and I would be happy to have Supriya around. If Supriya for some reason
all together.
If Supriya for some reason is not able to join us because of a work commitment, I should be at least allowed to spend time with my daughter.
So just to bring to notice that she is a little uncomfortable. She feels more comfortable in my presence.
Nay,
So-
Supriya, if we are asking Sanil to come down to India, at least some reasonable time. The whole idea is that if you all keep talking, perhaps we may be able to reach to some positive development. We may be able to achieve some positive development. So now it's a matter of understanding. Let him come down. He will give you the dates of his arrival. He can go back on 6th, no problem. We keep the matter on 5th. Perhaps during those days, Ananya's vacation would also be there in school. And with mutual understanding, you all can work out the
Yes.
meeting, right?
Yes.
Okay. So this is what we would like to suggest. You want to say something? Ananya seems to be harassing her mother. Yes. You want to say something, Ananya?
No, please.
No, please, Sacha. Ananya, you want to say something?
She said she wants to be addressed as Ziva. Can you please tell them to
Beg
call
your
me
pardon?
Ziva?
Yes?
She was saying, could you
Ziva.
please ask them to call me Ziva and not Ananya?
Diva.
Ziva.
Ziva.
Diva.
Ziva is a middle
Her
name.
real
Her
name
middle
is
name.
Ziva.
Oh my
Yeah.
goodness.
Middle name is
We
Ziva.
tender our apology to you, Ziva. We had no idea at all that Ziva is your name and not Ananya. So
It's also
Ziva,
my
you
name.
can come online now.
It's my first name, Ananya, but
Oh yes, yes.
sometimes
Ziva.
I
Yes, Ziva, you want to say something?
don't.
Nothing? Okay, you come on 5th. We'll offer you a very good pizza and some chocolates also. So hoping to see you and your mother on 5th of January, 2026. We will wish you both a very happy new year also. Your father
Thank
will
you.
also fly down from US. You all have a good time, move around. Okay?
Thank you so much.
Done, Sanil? Done.
Yes, sir. Yes. Yep. I'll be there to see you.
Okay. Okay.
Very grateful, my lord.
Take down. Take down.
Thank you.
Just, chale gaye. The parties,
Yeah.
the husband, Sanil Shri Kumar, joined online from US. Supriya joined online from Bombay. The parents of Supriya are also online. We had the pleasure of talking to Ziva, right?
Yes.
It has been understood between the parties that Sanil will fly down from US to Bombay sometime in the week commencing from
24th December.
20th of December 2025 and would stay back at least till 6th of January 2026. We have requested the parties to plan their meetings accordingly with Ziva and have a good time. Whole point, right? We post this matter on 5th of January. Fine? Okay. 3 p.m. 3 p.m. All the best. Fine.
We're grateful. Ma'am.
Thank
Grateful.
you. Thank you. Thank you.
Thank you, sir.
So would this be 25th? I didn't quite catch that.
25th what?
Because that's when her school closes. Her Christmas
No, no,
vacations
no.
is 20.
We have said that he may plan his visit
Okay.
from 20th onwards.
Okay.
Ah.
Because she has
And
school
it's all right.
vacations at 20. Okay.
If she has school, no difficulty. Otherwise, all three of you can sit, plan out, have a good time. And
Thank you
we
so
will
much.
again now talk on 5th of
January.
5th. You can fly down to Delhi
Sure.
with Ziva,
Yes.
right? Sanil will join online.
Sir, I will be there in person, sir.
Oh, I'm sorry. I'm sorry. It's 4 o'clock now. That's why. Huh? So you will be also joining. And Supriya, let your parents also accompany you.
Sure.
And Sanil?
Yes, sir.
Sanil?
Yes,
You
can you hear me?
will forward the tickets from Bombay to Delhi for Supriya, Ziva, and your in-laws. Okay?
Yes, I will forward my tickets to them.
Okay.
Yeah.
Okay.
Grateful.
Not your tickets, their tickets.
It will be done, my lord.
Ah, okay.
Grateful.
Thank you.
So indulgence, my lord, in one matter, regular list item 108. I will not be here, my lord, next week, in the coming week.
And keep it after vacation.